Good morning and welcome to the 28th meeting of the Net Zero Energy and Transport Committee for 2025. I'd like to welcome to the committee Sarah Boyack, the Labour Party's substitute. Under Rule 9.13a of our standing orders, Monica Lennon is not entitled to exercise the rights of a committee member in relation to agenda items 1, 2 and 3. This is because she is the member in charge of the bill the committee will be considering under those items. So under these circumstances, the Labour Party substitute member, Sarah Boyack, is entitled to take her place. Monica Lennon is, however, attending our meeting, and like all members of the Scottish Parliament, she's entitled to attend the public evidence session. And in accordance with the way I've always run committees, I'll give her a chance to ask some questions of each panel at the end of that. When we get to agenda item 4, which doesn't concern the Ecocide Bill, Rule 9.13a no longer applies to Monica Lennon, and I understand that she will take part in the agenda item in her capacity as a committee member, and Sarah Boyack will not take part in that item. I hope that's all clear. Just to confirm as well, so there's no confusion, agenda item 4 will be taken in private, but that's the way it will happen. So on that note, our first item of business this morning is to take a decision on taking items 3 and 4 in private. I prejudged it, but item 3 is consideration of the evidence heard on the Ecocide Scotland Bill, and item 4 is consideration of a draft report on the Climate Change Scotland Act 2009 Scottish Carbon Budget Amendment Regulations 2025. I hope we're agreed to take these items in private. Are we agreed to take these items? We are agreed. So our first item of business this morning is an evidence session on the Ecocide Scotland Bill, a members' bill introduced by Monica Lennon, MSP. It's our first evidence session on the bill at stage 1. Our role at stage 1 is to gather evidence and information to decide whether to recommend that the Parliament supports the general principle of the bill. And we ran a call for written views on the bill over the summer, and today we're going to hear from 2 panels representing a diversity of interests and expertise. Firstly, I'd like to welcome Jamie Whittle, the Chair of the Environmental Law Subcommittee at the Law Society for Scotland, Professor Valerie Fogelman, Professor of Law at the Cardiff University School of Law and Politics and a consultant at Stevens & Bolton LLP, Sue Miller, the Chief Networks Officer at Stop Ecocide International, and Dr. Shivali Fifield, Chief Officer at the Environmental Rights Centre for Scotland. Thank you all for attending this morning, and thanks for all of those people who provided written evidence to help us prepare for the session this morning. Now, as is generally the way, I'm going to start off with the easy questions at the beginning. So, the first question is, and I'm going to put it to each of you, is a new offence of ecocide needed in Scotland? What are the opportunities for the bill for tackling the climate and nature crisis, and what do you perceive as the limitations? Now, that's a really open-ended question. You're not going to get half an hour each on it. A couple of salient points from each of you, so you don't steal each other's thunder. And because Valerie's in the room, I'm going to let you start, Valerie.
Thank you very much, and thank you to the committee and especially to Colin for inviting me here. It is needed, and I'm very impressed by it. I think it will deter environmental damage, environmental harm. I think it's very well put together, except for one thing, and that is the compensation. And I don't think that will work. Simply because, as Colin knows, I'm probably here because of the work I've done on the Environmental Liability Directive with the Environmental Liability Regulations in Scotland. And there is a duty on anybody that causes environmental damage within the confines of that, of those regulations. And granted, the Ecocide Bill is a lot broader, but putting those two together is very, very difficult because it's not a discretion under the ELR, it's a duty. And yet the what the bill is saying is that you can seek compensation if somebody else, including SEPA, does the remediation. But that's a discretion, whereas the competent authority is a duty to require the person that caused the environmental harm to remediate it. So I see a tension. That's really my main point. I had a couple of very, very small points. The policy memorandum refers to climate change. I'm not certain, is that included or not? And I think it should maybe also, the bill should include preventive measures, because in work that I've been doing for the European Commission on the ELD, it's quite often the preventive measures that cost the most, that are the most significant, more so than when environmental harm has been caused. So that's keeping it short. I'm open to any questions, obviously. Thank you.
And I'm sure you'll get lots of questions during the course of this morning. Jamie, as you're at the top left of the screen as I'm looking at it, you're next.
Thank you, Convener. Good morning. Good morning, committee. Thank you for including me. Yes, certainly the position of the Environmental Subcommittee at the Law Society of Scotland is that we welcome the introduction of the bill. We recognise the need for a stronger legal mechanism to punish severe environmental harm, particularly given the twin climate and nature crises, which Ms. Convener, you referred to in your opening comments. It's really setting against that context that if Scotland is serious about its attitude towards the climate crisis and the nature crisis, then there needs to be this backdrop context of stronger environmental protection. I think what the bill will have the effect of doing, and not just in terms of potentially sanctioning those who cause harm, it's the culture change that it will potentially bring about that I think is really important. And we've seen that in other examples of environmental law before, where, for example, with wildlife crime a number of years ago in the Wildlife and Natural Environment Scotland Bill, vicarious liability was introduced, and that had a significant effect on the attitude of people across Scotland, and brought a greater visibility of the need to act in particular ways, and with that, an attitude towards environmental risk. So as a general comment, we support the introduction of the bill. There's comments that we've made in writing that I'm happy to pick up during the session on, perhaps more from a mechanical point of view, how the bill might be implemented into law. There's obviously a close relationship with the Regulatory Reform Act, and whether or not it would fit more coherently to be embedded alongside that than necessarily stand alone. But thank you.
Okay, thank you, Jamie. I think when you come back, Sue, you were next in line on the top line, so I'll come to you. Oh, something's happened to our screen. Right. I'm going to suspend the meeting there just while we sort out IT problems, because I can't see it. So I suspend the meeting at this stage. Okay, I'm going to reconvene the meeting. We paused because somebody had lost control. I don't know who it was. I think it was the IT department of the microphones. So, Sue, I don't know if you got warning I was coming to you next, but you're next. Do you want to answer the question?
Yes, I did just. Thank you. Obviously, I'm with Stop Ecocide International, and so our sort of viewpoint is an international sort of one. So I can sort of come with sort of general principles and a comparative context and sort of a practical and non-technical insight. So in terms of what Ecocide can do, it's the regulatory, the legal framework around environmental law tends to be piecemeal and fragmentary. And what Ecocide law does is it creates a sort of a safety net, a sort of an outer limit, and a sort of a red line beyond which we say, well, this, things beyond this point are not acceptable. So the opportunity is that it gives a sort of a clear demarcation of what a community, a nation, humanity finds acceptable in terms of what we are prepared to put up with for sort of for development and for commerce and so on. And the objective is that it actually changes boardroom decision making, because as well as looking at the profits and the risks and the normal sort of risk assessment, it obliges those making the decisions, the key decision makers, to take into account their personal liability. And that somehow changes the way people look at things and encourages them to check that all the safeguards are in place. So we think it will have a huge effect on decision making. We think it will also change investment flows and encourage investment into more sustainable practices and research and development into doing things better. So a huge sort of opportunity to really shift our sort of humanity, our activities into a safer space. In terms of limitation, well, I guess resourcing is always one. The sort of the enforcement, the resourcing that you put behind it is always going to limit how effective any such law can be. So those are my contributions at the moment, unless anyone wants to ask me anything.
No, I'm trying to keep the questions on theme, so people will come and ask you questions afterwards, I guess. So, Shivali, do you want to come up next?
Thank you, Convener, and thank you again for inviting us to speak today. So I'm the Chief Officer for the Environmental Rights Centre for Scotland, or ERCS for short, and I echo particularly what Jamie and Sue have already said, so I won't repeat what they've said. But I will add that as well as the twin crisis of nature and climate, we talk about, and the UN talks about, the triple crisis of nature, climate and pollution. And I think the reason why this bill is welcome and needed is because it does add, as Sue says, an overarching offence at the top of what we would call the regulatory pyramid to address the most serious forms of environmental harm. And I think that that's important for Scotland. We already know that the majority of pollution and damage, environmental harm, is cumulative impact of lesser acts. But in the rare occasion of a significant incident, our current legal framework is lacking. So that's why I think it's needed. I think the opportunities are very clear, as Sue and Jamie have said, about challenging the current social licence of polluters. And I think that's really important as well. So in summary, we support the general principles, but the limitations, we identify 3 areas which we believe need to be clarified and strengthened, and I'm sure we'll talk about them more in detail, but just to summarise them. The first is that definition should include emissions as well as acts. The liability provision should only apply to relevant organisations and relevant officials, and at the moment the bill is not strong enough to exclude workers, and we are very worried that workers will be scapegoated. And we do need further clarification on the defence of necessity. So those are 3 current limitations that I'm sure we can address through stage 1, stage 2.
Okay, thank you. I'm now going to ask a couple of specific questions to individuals. So my first one, I guess, will be to Jamie, to give you a chance to prepare, Jamie. I know it's coming at you. Definition of ecocide. Is the bill's definition of ecocide, or the definition in the bill, sufficient? Does it define it?
Thank you, convener. Our view is that it does. And there is the definition there of the severe environmental harm, and that's cross-referenced into the Regulatory Reform Act, which I can just pull up on my screen in a moment. But certainly, no, our view is that it's clear in its extent. And for it to be severe, it's got to have serious adverse effects and be both widespread and long-term. So it's looking to capture environmental harm of the highest, most severe order.
So my question then is, does anyone on the panel of witnesses this morning think that the bill doesn't define it sufficiently? If you don't think it defines it sufficiently, you can just raise your hand, or you otherwise are agreeing with what Jamie just said. You've all looked away perfectly. Okay, I understand that. And then my final question on that is, no, I think I'm going to move straight on to the next question, which is going to come from Kevin. Kevin, over to you.
Thank you very much, Convener. I'd like to explore what the key differences are between the proposed offence and the existing offence of causing significant environmental harm in Section 40 of the Regulatory Reform Scotland Act 2014. And I'd also like comment from panellists around about why they think it is that there have been so few prosecutions under Section 40. And we'll start off with Valerie, please.
Right. The Regulatory Reform Act has doesn't cover prevention, right? There can be a remediation order, but there's also a defence for compliance with the permit. And you can, what the Ecocide Bill is, it's an autonomous offence. It doesn't need compliance with the permit or anything. It stands on its own. And I think that is very significant. That was a big issue with the Environmental Crime Directive in the EU, and whether the EU had competence to come out with an autonomous offence. And they got away from that. They managed to do it. Now, Scotland is obviously not bound by the competences. It's got competence to do that. But I think you do need to get away from that compliance with the permit being okay. A lot of permits are very, very old. If I may just give you a very...
So in which case then, a lot of permits are very, very old.
Yeah.
We've got Section 40 of the Regulatory Reform Act, which has hardly been used, let's be honest.
Yeah.
So why don't we modernise the permit system and the compliance with the permit system and ensure that Section 40 is used more rather than introduce a raft of new legislation?
Because it's very much to do with regulatory offences, isn't it? It's looking permit type offences. I think what the Ecocide Bill does is it stands apart from this as this autonomous offence.
I get that point, but if somebody has complied with a permit and you're saying that that's not good enough at this moment because it hasn't been modernised, why would our first course of action not be to actually ensure that the permit system and compliance of is modernised? And why would we not ensure that existing legislation is as tight as it could be and actually used? I have to be honest with you, and you know, I'm playing devil's advocate here, but also I don't see the point of introducing new, supposedly overarching legislation if the current set of legislation does not work in the modern age, if you get me.
Well, it doesn't seem to be working, does it? There's no prosecutions. Why? I don't know. Is it to do with, obviously, money? It's a big thing with SEPA. The money isn't there for enforcement these days. And I do think the permit system needs to be reviewed. If I may give you just one very quick example. In England, in the Lake District, Ennerdale Water, United Utilities has a permit to abstract water from the River Ayan that comes out of Ennerdale Water. And what the United Utilities was doing under their permit, they were basically destroying one of the last populations of freshwater pearl mussels. The Environment Agency couldn't stop them because they were complying with the permit. So what they cleverly did is come out with a preventive order, and they started then ratcheting down what that permit, how much water could come under their permit abstraction permit. Now, in such a case, for example, would United Utilities fall under the Ecocide Bill? Because they were wiping out, basically, one of the last viable populations of freshwater pearl mussels. And I think that is an issue.
Well, they wouldn't come under the Ecocide Bill because you're describing something in England and not in the Scottish jurisdiction. Mr Whittle, please. I
mean, in terms of the overlap really between the two, in addition to Professor Fogelman has just said, I mean, elements are that there's a narrow mental element of the new proposed offence. There's a narrower provision on corporate liability in the Ecocide Bill because neglect isn't included in the way that it is under the Regulatory Reform Act. There's obviously the additional vicarious liability provision that's brought in. Probably the most striking is the more severe maximum penalties with the 20-year imprisonment element. And then there's obviously the reporting requirement too, which is proposed.
Okay, I'm going to come back to something that you said earlier, Mr Whittle, in a paraphrase. You said that a change in the law would lead to culture change. Now, I'm quite long in the tooth in this place, and I have to say that changes in legislation do not automatically lead to culture change. What makes you think that this proposed bill would lead to that culture change?
I think it's the severity or potential severity of the punishment that would be levied on an individual or organisation that was deemed to have committed ecocide. It is, I would submit, a striking difference between the level of penalties that are there under the Regulatory Reform Act, and it's the type of level that grabs attention, and with attention becomes the need to look at organisations' policies, the way in which they operate, their attitude towards risk, the way in which organisations and leaders of organisations, I would suggest, are more likely to take greater interest in the way in which they carry about their affairs. So that is why I suggest there is a culture change that comes hand in hand with realising that there are severe consequences for breaking the law.
So was there culture change after the introduction of Section 40 of the Regulatory Reform Act? Is that the reason why we're not seeing any prosecutions there? Or prosecutions
I can't give you any statistics, I'm afraid, on that. My impression, for what that's worth, is that there was certainly a growing awareness of when that came in, but the jump is much more significant with what is proposed under the Ecocide Bill.
Sue, please.
Yes, obviously I can't speak to Section 40. I'm not an expert in Scottish law, but going back to the question of permits, permits are granted quite often because of commercial expedience or because of the strength of particular lobbies, and you may find that permits are granted for things that do turn out to be ecocidal, so or might be found to be ecocidal. So having this sort of outer sort of ring of what is acceptable will actually govern which permits are granted in the first place and bring that level of activity into the safe space. So I think from the sort of the point of view that I'm coming from, which obviously can't comment on Section 40 in any detail, I think that the granting of permits also needs to take into account the potential for ecocidal activity.
So in which case it would probably be more logical to deal with modernisation of the permit system before you introduce a bill or legislate for something which will overarch a system that currently, in your opinion, doesn't operate very well.
I can't say because I don't know how the permit system works in Scotland, but I think the important thing is that there is this outer limit and there is this line in the sand which makes a statement about what is acceptable and what is not acceptable, and ecocide law will do that. And also it will chime with what is going on internationally because the ecocide law is progressing at the International Criminal Court. So gradually systems will converge on some sense of agreement on what is acceptable.
Okay.
And Scotland will be taking a lead in this.
I think, you know, Scotland always likes to take a lead, but, you know, you've just said that you're here today, and I understand the reason why you're promoting Ecocide as the Network's Officer of Chief Ecocide International. But in terms of Scottish legislation and the current permit system, you've just said that you do not know how it all operates. In which case, you know, why is it that you think that, you know, what is proposed here is the right thing rather than modernisation of the existing systems, which may well lead to quicker and better improvements in these areas?
I can only speak for non-technical things related to Stop Ecocide International's global movement, so that's what I can answer questions on.
Shivali, please.
Thank you, Mr. Stewart. So I think all I'd add is that in some ways we're talking apples and pears, that I don't disagree with you that we need to improve the permit system in Scotland at all. But in terms of the SNP commitment, the government's commitment to keep pace with the European Union, the Ecocide Bill is very much around responding to the EU Environmental Crime Directive. And currently, the RA does not cover the most serious environmental harm as defined in the new bill, and doesn't cover the sanctions that correspond to that most serious of crime. So we do see it as an extension of RRA, not instead of. And that's something that currently is a gap in environmental governance in Scotland. There are many issues with environmental governance in Scotland, no doubt about that. But this is an addition, not a substitution.
Okay, thank you. That's helpful. I'm a very logical person when it comes to legislation. And I think that sometimes we take the most difficult paths to get where we want to go. In that logical sense, would it not be wiser to, first of all, look at the permitting system across the board and modernise it, and look at where the Section 40 is not working before we put in any further additions? Now, you know, I want to see Scotland keep up with our European partners in terms of almost every single aspect of life. But logically, you know, in all of this, would it not be best to deal with those matters that I've discussed first before we move on? Because those items could probably be dealt with much quicker than a bill which has been discussed right at the tail end of a parliament and is unlikely to make progress. And I'm sorry for saying that, Monica, but that's the reality here. Shivali, please.
So I think reviewing the whole permitting system it would be really welcome, but I do think that would take a huge amount of time. One of the issues currently with the lack of enforcing our current legislation is resources, and that's something which we have talked at length about in terms of reviewing environmental governance. I won't go down that rabbit hole just now. But I think that in terms of whatever we do, even if we have the best permitting culture, the point about this bill is to address the once in a lifetime, we hope never, but once in a lifetime event, and actually address the outcome of that action. So I think that's another thing which is quite important about the Ecocide bill, is it actually is looking at the impact of an action and not only the prevention bit, which is what permits are meant to do.
So, again, playing devil's advocate, and, you know, we would all prefer that some of these things didn't happen, but you've talked of a once-in-a-lifetime event. So let's say that this bill passes, it is enacted, and a once-in-a-lifetime event occurs, and that leads to court action. And the defence from the folks who have committed the offence is, well, we did all of this within the permits that we have been given, and we have not actually modernised the permitting system.
Right, I'm going to suspend the meeting again because we've got an unstable connection. Sorry, Kevin, to cut you off from mid-flow. So the meeting's suspended. Okay, I apologise to those people online and those watching this. I'm sorry for the continued interruptions. I'm told it's a gremlin in the system and there's no reason for it. So we'll just have to work through it. And as a way of working through it, we get to hear what Kevin was saying again. So twice, Kevin. Off you go.
Thank you, Convener, and let's hope it is only twice. I think you maybe got the gist of where I was going, Shivali, in terms of playing devil's advocate again. You know, we have got a situation where the Ecocide bill has been enacted. An offender appears in front of court and says that we did everything in line with the permitting system. And we haven't modernised the permitting system. How is a court going to react? I know that's a difficult scenario to guess, but my thoughts would be that a court would say, oh, well, they've done everything within the permissions that they have there, And it may well be that that overarching ecocide legislation does nothing because we haven't modernised the permit system around about it. Any comment on that, please?
Oh, sorry, that was directed to me.
No, Mr. Chevalier, please.
Oh, I'm unmuted, sorry.
Thank you. Yes, I'm unmuted. So again, I think we need to do both, and I can't stress that enough. So we absolutely do need to reform our permitting system. But let's think about that scenario. I think one of the things I hope we're going to come on to is where I think the liabilities in the bill do need to be strengthened. And we do propose a strict liability for organisations, what we call relevant organisations. So in this scenario, there would be two things. If an organisation, a relevant organisation, a corporation, was behaving in a way which they knew would be detrimental to the environment, or they thought they could be, it's their responsibility to address that. And I think that whether they're working within permits or not, there's lots of other duties and responsibilities for organisations to prevent an ecocide level crime. And I think that's where a strict liability offence is important for organisations. So I think that's the first thing I would say. And I think the second thing I would say is that I think as Professor
Valley, I don't disagree with you in anything that you've said there at all. But what I'm getting at is the point. You could have this bill enacted, an offence could happen, and the defence of an offender could be that we have stuck completely and utterly with the permissions that we have. And, you know, again, I'm not a lawyer, but that's a pretty good defence, I would argue. So surely what we have here is actually putting the cart before the horse, is it not?
I think I'll just say again that I think we need to do both, and that in itself, under this bill, as I understand it, would not be an appropriate defence, because we would want it to be a strict liability offence on the balance of probabilities. But I see Jamie is probably more equipped to answer that question.
Jamie, do you want to come in there?
Thank you, Mr. Stewart. I was just going to add, it was really, in fact, picking up on Chevalier's last point there. One of the differences between the Ecocide Bill as proposed and Section 40 of the Regulatory Reform Act is that under the Regulatory Reform Act, there is indeed the defence in relation to permits that if actions were that would otherwise have been an offence were carried out in accordance with a permit, then that can be a defence. Under the Ecocide Bill, that defence is not present. The defence is based on necessity under Section 2 of the proposed bill. So, as I see it, this is this element of ecocide is it's essentially a layer over and above beyond what may or may not have been permitted. It's to cover situations such as a massive oil spill, such as, you know, the example of the Deepwater Horizon incident in the Gulf of Mexico, where things were of just such an enormous scale that would go far beyond any permitting, and it's dealing with those very severe levels that go beyond the more regulatory level of things. So. And also, you know, as Chevalier has said, I wouldn't suggest that what's proposed here needs to be parked whilst any review of permitting is perhaps reconsidered. What I would suggest, and it's been a consistent theme of submissions made on behalf of the Law Society, is that there is a real importance to have coherence in environmental law, the way in which our laws and our regulatory work and resourcing all runs together. So as part of this, we put in our submission, we would suggest appropriate to also look at the environmental liability regulations as well, and just to make sure that they are all fitting together in a coherent way.
Okay, can I just get this right for the record? You were saying that permitting would not be a defence when it comes to this bill if enacted?
That's certainly my understanding. The defence that's set out in the Ecocide Bill under Section 2 is of the defence of necessity, whereas in Section 40, subsection 6 of the Regulatory Reform Act, that has a defence that links into regulations.
Okay, thank you. Thank you, Convener.
Thanks, Kevin. Michael, I think you've got a brief question here before I go to Mark.
Yes, good morning. I just want to be clear, because I think it's very important that before introducing any provision that creates new criminal law, that we are very clear about the gap in the law that we are trying to address and the nature of that gap and how the new offence would operate on a practical basis. Can I therefore ask you, in the course of, given the definition of ecocide within this bill and how that then relates to the Regulatory Reform Act provisions as they stand at the present moment, in the course of the last 10 to 20 years, can you give me a practical example within Scotland where the existing regulatory framework has been insufficient to deal with an offence that this new criminal act would have actually allowed us to prosecute the individual or organisation? Can I come to you, Jamie, just given your expertise in particular in Scots law?
Thank you. Off the top of my head, I can't think of a specific instance. But I will, I'm happy to come back to the committee further in writing if that would assist.
Be helpful. Valerie?
Maybe it's the Brer. I mean, the Brer was given as an example of the various submissions on this bill. That would fall without the permit defence. Now, okay, if, say, the Brer had been caused by negligence, for example, or, I mean, it caused a lot of devastation. I think that would fit very well under this bill.
Okay. Remind me of that example.
Pardon?
Can you just remind me of the circumstances of that example?
Oh, gosh. It's been a long time since I've read about the Brer, I must admit. But it was, as they typically are in the marine world, it was an oil spill that caused a lot of devastation. And I know it caused a lot of businesses, a lot of financial problems. For example, ferries, sightseeing, etc. Fishing, obviously, is a very big one when you're looking at a marine oil spill. Okay. Now, I'm not saying the Brer, I'm sorry, I can't remember exactly what the facts of the Brer were, but that is the kind of example. If there'd been negligence, say, like in the Exxon Valdez, and the master had run aground because in that case they said maybe he'd had too much to drink, for example. Yeah. That would be an example, I think, where this bill would fit very well.
I understand the issue of concept and importing an example to try and fit that concept, but in the example that you've given, you don't know whether the existing definition in this bill would have actually applied to those circumstances. Is that correct?
No, I think maybe another example is I think the bill is not only looking at incidents, it's also looking at a pattern of wrongdoing. For example, I'm sorry, I can't speak to Scotland on this, but in England, we've got a massive problem with the water companies continuing to cause pollution of waterways. I think that would apply.
Before we go too further, I'm really keen to have an open discussion. What I'm not keen is trying to point a finger at somebody who might or might not have done something, because they might then turn around and say that as an act of defamation is carried out in the committee, that somebody has accused them of doing something. I think the principle of the idea, rather than saying a individual has done something, would make me more comfortable as convener. Sorry, Michael, just to protect me and you and the other members of the committee. Yep, sorry, Valerie.
No. I think part of this bill, it is onerous. No, without a doubt, it's onerous. I mean, I was practicing law in Texas in 1987, where environmental law offences became very significant. And we used to jokingly refer to the designated felon of a company if something went wrong. And it did have a very big impact when you're looking at an individual in a company and saying, you can't get away with a fine for this. You may actually go to prison on it. And it changed the culture. I think the other witnesses were talking about a culture change. This is a culture change. And I think as well this bill would bring us closer, bring Scotland closer to what the EU is doing with the Environmental Crime Directive. In fact, a lot of this bill is kind of patterned on what the ecocide under the Environmental Crime Directive.
I don't, Shivali, do you have a view on this, given your interest in Scots environmental law?
I think, as Jamie has already said, and in our previous communication with Monica as well, looking at the consultation process, at the moment we haven't been able to identify a specific ecocide level crime in Scotland in the last 5 years, but the potential is what we're looking at. And I think, as you've already said, we are looking at things which are similar to significant oil spills. And yes, we hope we'll never get there. But I think the point about this bill is, if that were to happen, do we have the mechanisms to address that? And also, by having a bill, as has already been said, it will, we hope, shift the balance of probabilities for people to think about more pro-environmental acts and a just transition to less pollutive industries and practices.
Okay, thanks.
Okay, Bob, you wanted to come in then, Mark.
Just very briefly, the Bill of Oil Spill was 1993, so I think the legislation underpinning the current legislation supersedes that example, but I appreciate why that example was given. What I'm trying to get my head around, maybe Mr. Whittle might be best to come in, is, yeah, we've got the Regulatory Reform Act of 2014, Section 40, which has been cited by Kevin Stewart, which deals with significant environmental harm. I was having a look at my briefing there. There's also the 2009 Environmental Liability Scotland regulations, which talks about companies and organisations having to take preventable action, so proactive stuff, and remedies also. I'm sure there's other parts of the legislative landscape that I'm generally not aware of. I'm learning as I go along here. So I think the Deputy Convener's question was whether there's any examples in the last decade or so where the legislative framework has not been fit for purpose to deal with a significant environmental incident. I don't think we've got clarity in relation to that. But also, I'll do a second question, I won't come back in because of time constraints to Mr. Whittle, is who decides what piece of legislation to use when seeking a legal recourse? Because if this new legislation goes in the statute book, I think lots of people will be very keen to see it used, but it might be more appropriate to use Section 40 of the 2014 Act or the 2009 regulations. And I'm very conscious of setting legal precedents, which immediately sets the bar for what ecocide actually is. And it's meant to be such a significant threshold before you reach that. So, Mr. Whittle, could you give me some reassurances in relation to all of that, perhaps?
Thank you, Mr. Doris. I would anticipate that decision-making would be made ultimately by the Crown Office in taking forward a prosecution. It would obviously need to be informed by police and/or SEPA, but I would have thought that the way in which a conviction is processed would ultimately be the determination of Crown Office as to what's the most appropriate crime to pursue.
Mr. Whittle, could there be a situation where maybe the threshold of ecocide might be doubtful in relation to the law, but the Crown Office and others want to see greater penalties, but those penalties can't be imposed under the 2014 Act, so therefore they might seek remedy through this new legislation for greater penalties rather than it meeting the threshold of ecocide. Are there any dangers in relation to that, Mr Whittle?
I don't have any comment on that, Mr Doris.
Okay, thank you.
Mark, we finally come to you. I think you were waiting to come in on various issues.
It's been a fascinating session already, and I certainly welcome this bill coming stage one to this committee. Sometimes members' bills can highlight blind spots that government have, so I think it's a really interesting session. I wanted just to pick up on a couple of things that came out of the questioning from Kevin Stewart. I mean, firstly, we have this system of environmental regulation, environmental permitting. I'm interested in other jurisdictions that have adopted ecocide as a kind of overarching offence. Does that actually then drive forward reform of regulations, permitting, licensing, because there is a kind of an underlying fear that some of those regulations will not be fit for purpose, and actually, even though companies may have a licence under those regulations, they may ultimately, in a court of law, still be found to be committing ecocide in some extreme examples. I'm just interested in what, you have that overarching legal change in place. What does then that do in terms of driving forward, if at all, any further sort of environmental regulatory reform? Professor Fogelman, you're nodding vigorously. But
I mean, the countries that have done it, Belgium, for example, but looking at the EU, right, there is a wonderful article by Professor Michael Four that's looking specifically at the Environmental Crime Directive and getting away from these permitting defences. But at the end of the day, I think it's still coming down in silos. I don't think there's enough interaction between them that I've seen so far. No, I think a lot of this is out with the permits, but when you get to the permits themselves, no, I don't know if any of the other, Jamie, anybody, Shvali, have seen it, but I've not seen this interaction between revising permits and a bill, ecocide bill.
Yeah. Dr. Fifield, do you want to come in? Shivali?
Very briefly, I think because so much of international ecocide domestic law is so new, and I think that our report that we commissioned by Dr. Rachel Colleen and Professor Damien Short goes into that in great detail. So I would ask you to look at that, and I can send that, and also a more recent paper that Rachel and Damien have done on the impact of domestic crimes. But I think overall, as the previous speaker said, part of the EU Environmental Crime Directive is to ensure that there's an ecocide level crime as part of us improving the whole suite of environmental governance. And that also sits very well with the UN Special Rapporteur on the right to a healthy environment, Elisa Mogera now, but previously Professor David Boyd, who have done a lot of research on how including the right to a healthy environment has improved overall environmental governance, and has improved new legislation to support a just transition. And so I think that they have a lot more evidence on how recognising the right to a healthy environment has done that. And ecocide level crime is part of that suite as well. But I think Sue Muller might know more and have more examples than I do.
Yeah. Just before you go, though, I think it was yourself who mentioned earlier on about strict liability and about particular sectors that may have strict liability established. So that would be another kind of form of backstop. I suppose I'm thinking about situation, for example, where you might have the release of GM crops, for example, into the environment, or a GM fish, for example, that potentially could, let's say, decimate populations of wild salmon, something like that. Would that be an area where, you know, an ecocide law could perhaps focus more on the establishment of strict liability in certain situations, or do you think strict liability is really a separate conversation about environmental damage and how responsible certain sectors need to be?
So I think in terms of an ecocide law, we need to be clear that the Act is the thing that we are that we are trying to address. So what we've suggested is a strict liability offence for organisations, and what that then does is it makes I'm just going to look at my notes now so I'm really clear, because it can be quite confusing. It makes it a corporate offence to have committed an ecocide level crime. And that means that a corporation or any other body may be held criminal liable where severe environmental harm has been committed, as in our definitions. I think that as well as including emissions in the definition, will ensure that if there has been an ecocide level crime, we're looking at the organisation not having done something as well as doing something. And that's very similar to what's already covered in the RRA and also covered in the Environmental Crime Directive. So I think those two things cover a little bit of what you were talking about, Mark. But I think, to be very clear, we do not think an ecocide level crime, a bill, can be about something that hasn't happened. It can only be something that has happened. And I think that's a really important distinction about this bill. And the first speaker talking about prevention, the only way the ecocide bill can be about incorporating the prevention principle is by acting as a deterrent.
Okay, thanks. Can we move on to other speakers online? Yeah, that's great. We've got the screen back. Sue, can we move to you?
Yes, thank you. So in terms of the first question about other countries, Ashfali said it's very new at the moment. Now, ecocide laws have been around for 20 odd years, many of them in the former Soviet countries, because they will have to write their constitutions at around about the time of the Code of for the Peace and Security of Mankind, which was a forerunner to the Rome Statute. So a lot of them brought in ecocide crimes into their constitutions at that stage. Now, I'm not aware of any of them ever being used, and I think that's something to do with the definition, that it simply wasn't a practical definition. The first country that's actually brought ecocide into its legal system based on the definition drafted by, we call them the Independent Expert Panel in 2021, which is the definition that we use at Stop Ecocide International, and the one that's been proposed at the International Criminal Court now, is Belgium. And it's so new, and the threshold is so high that it only came into force, I think, last year. So there have been no cases on that. So this is a sort of an unfolding sort of progress, if you like. But I think in terms of we were talking about the advisory opinions and sort of the International Court of Justice. Following the International Court of Justice's advisory opinion, which I think came out in July of this year, states have got new obligations, and they have to prevent environmental harm. And that is a Juice Kogan's. That's the Inter-American Court of Human Rights. That is a duty that they have, is to prevent environmental harms. And so with that sort of duty expressed in, by the United Nations highest court, that means that states need all the support they can. So by introducing something like an ecocide law, that actually helps them to meet those obligations, because it helps to focus the minds of those involved in the activities that might cause ecocide law.
In terms of individual, is there examples of individual states that have gone back as a result of an ecocide law and said, okay, we're concerned that our environmental regulatory framework is problematic, there are holes within that, and we need to, in light of the ecocide law, go back and actually improve that?
Well, in Colombia at the moment, they are looking at their environmental laws to see whether they can bring them into line. They've got quite good environmental laws, but they want to bring it closer into line with the definition. And Chile also, once the definition came out, looked at and consolidated its existing laws and said, actually, we've worked out that we almost reach that threshold. So there are certain states, particularly those where there are, who are more vulnerable to ecocide, who are reviewing their legal system, saying, okay, how can we bring that into closer alignment with what's going on internationally and with this definition? So those are a couple of examples I can.
Thank you for those examples. Jamie?
Thank you, Mr. Ruskell. I don't have a practice in international environmental law, so can't really comment on comparatives of what's going on in other countries at the moment. What I was going to add, in case it is of some help, I alluded at the beginning of the session to a piece of legislation that came in some 14 years ago, the Wildlife and Natural Environment Scotland Act, which introduced vicarious liability potentially for landowners if they had an employee who was found culpable of committing wildlife crime. And the comment I was going to make was really I thought it was a very striking example of where there was culture change as a result of that being introduced. You saw employment contracts being rewritten. You saw employees being sent on CPD courses to make sure that they were aware of the effects of the committing of wildlife crime. This is particularly focused on raptor predation. So it's more an in Scotland example, but I think it was a very effective one to all intents and purposes.
Yeah. So obviously, in that example, it's had a cultural impact on the way that businesses operate. But I'm just interested in you just addressing the question, though, around whether you see an ecocide law would effectively encourage Scottish Government regulatory bodies to review existing legislation. I mean, I think the assumption perhaps in this room is that Scotland's environmental legislation is fit for purpose, but is that your view? I'm aware that, for example, with mineral permissions, the legislation for that goes back to 1974. So, there's the adoption there of regulations which are really, arguably, many communities believe not fit for purpose in the modern world. But what's your overall view of environmental legislation in Scotland, and do you think that an ecocide bill like this would drive reform? Is reform needed?
I've in evidence given to a previous committee in relation to, I think it was in relation to environmental governance, I'd made the comment, and it's consistent with submissions made on behalf of the Law Society, that Scotland, since devolution, has introduced some incredibly progressive pieces of environmental legislation, whether it's the Climate Change Scotland Act, the Nature Conservation Scotland Act, our policy on wildland, for example, things that don't necessarily exist, certainly south of the border, or that are necessarily driven by the EU legacy. So I think it's fair to say that Scotland has been a particularly progressive country in terms of its legislative programme for the environment. Where there may be weaknesses are those relating to governance more widely, and the way in which we have a very fragmented world of environmental law, which can be difficult to follow and difficult to piece together. And so when there is the opportunity for coherence, a refresh, to make sure that things fit together and aren't inconsistent, and picking up a comment earlier just about the critical importance of resourcing these the implementation of these good laws, that's absolutely essential. And indeed, that was a comment that we made in our written submission, that so much of this proposed ecocide bill hinges on the ability to resource what is required to follow through with it. So in answer, I don't see this bill in of itself triggering the need for an overall refresh of the environmental array, but I would suggest that what's important is the way that this is placed sits within a coherent context, so that it's understandable and that there is clarity.
Yeah, Shivali, did you want to come back in on that point?
We go on. I'm just going to make the point, if I may. We're less than a third of the way through the questions, and we're 3/4 of the way through the time. It always happens when you have interesting panels. So be mindful, if I may, to panellists, is that the longer you speak, the more you ensure no one else can speak, and the less chance we'll get through all the questions. So you're going to have to face your colleagues, not me, after this. I'm going to have to face committee members. So please keep your answers short and concise. Please. Sorry, Mark.
I was going to ask Shivali if she wanted to come in on any of those points. Okay. Right. My final question then, I think Jamie's already answered this. If I could get very brief responses from others, is just around that cultural change within organisations, within industry. Do you have evidence of where the introduction of an ecocide law has driven that cultural change? I think, Jamie, you've already used an example from a previous environmental law in Scotland in relation to vicarious liability, but I'm interested in the other panellists' views as to specific examples of where you think culture change within certain sectors has happened. Valerie, do you want to come in? Valerie, do you want to come in?
Sorry. I can't speak for Scotland, but I can definitely speak for the US, especially Texas. I think the difference is an individual can go to prison. That takes it away from, we can put it fine out of profits or whatever. That is a significant culture change. And when I was practicing in Texas, yeah, I saw that.
But what does that mean? I know what that means for the individual, but what does that mean for the organisation? What changes as a result of that?
The organisation becomes a lot more aware. So the company becomes a lot more aware of what its environmental obligations and liabilities are. And they put more money into complying with those obligations, because now it's one of their own.
Right. Okay. Sue?
Yes, I don't have specific examples following ecocide because, again, it's so new, it's in development. When I was in practice with a law firm in the UK, when the data privacy regulations came in, I can tell you that with the possibility for the managing partner was looking at a prison sentence with if there was a data breach, we certainly changed the culture within the firm. So I think it does have an effect. It makes the firm leaders think twice.
Okay. Shivali? Shivali?
Oh, yeah, thanks, Mark. I think I've answered this already in that, again, because the laws in Belgium and France are so new, it's very difficult to see the direct sort of causal link. But again, the example the UN Special Rapporteur have done on recognising the right to a healthy environment shows how recognising the significance of needing to address that triple planetary crisis has led to better environmental governance and better laws, and supported organisations and companies to shift to more environmentally friendly practices. And I can share those with the committee post this evidence session.
Thanks, Shivali, and that would be helpful. Right, I'm going to try and move things along quite quickly. Defence of necessity. We've heard from various witnesses whether it's required or not. So my question is a simple yes/no answer from each of you. Defence of necessity, is it required? Jamie?
Yes, convener.
That's all right. Yes was fine. You only get a short answer. Sue, yes or no?
In the Scottish context, I can't say. Can I abstain?
Abstained. Right. Shivali? I can't hear you. Sorry. For some reason, you dropped off. Try it again. Yep. Go for it, Shivali.
Thank you. So sorry, I'm going to be I'm trying to be quick about this. We wish it wasn't, but we believe in terms of the concerns the Scottish Government have raised and in terms of the European Convention on Human Rights, Article 6.2, that it's something that we would need to accept in principle, and that it's a defence that can be relied upon by both relevant organisations and officials. But we do support what's in the bill, that the burden of proof for the defence is placed on the accused on the balance of probabilities. But most importantly, the defence needs to be clearly defined, and at the moment it's not. So we accept it needs to be there, but there needs to be greater definition of greater harm and exactly how that defence would be used, and whether it would be an objective or a subjective test. And we can provide more detail on that too.
So I think that's a yes in principle. Right. Sorry, a very long yes/no answer. Valerie, see if you can do a yes/no answer for me, please.
Can I do a perhaps? I think it's more important that the authorities have got the discretion whether to bring a prosecution or not. Okay,
so I'm trying to give this a real-life scenario. Let's see if I can do that. You've got a river in Scotland, doesn't matter where it is, where the water is abstracted to create power which goes into the national grid, and where water is abstracted to provide drinking water for local communities. Water levels get critically low, as they have, say, for example, this year, and taking the water off means that a freshwater mussel population gets destroyed. It's ecocide because they're definitely an endangered population. Is the argument that it was defence necessary to give power to the national grid or actually provide local people with drinking water? Who's going to make that decision? Valerie, you're shaking your head. I think local people might be kind of annoyed if they can't get a drink of water in the evening.
The defence isn't, I think, doesn't deal with that situation right now because it says greater harm, to prevent greater harm. Is it harm if you can't get drinking water?
Well, you'll probably die at the end of the day if you can't drink.
Yeah. I think that that would have to be that defence would have to be revisited to cover that kind of situation. And that goes a little bit to my Ennerdale water.
It does a wee bit, but it also feeds into Kevin Stewart's principle that if the permits have been properly issued in the first place or reviewed in line with the current changing things, this situation wouldn't have arisen. Okay, so I'm just going to move straight on because there's lots of other committee members who want to come in, and I'm going to move to Sarah. I think you've got the next ones.
Thanks, Convener. Yeah, I'm going to ask some questions about liability and how it's defined in the bill. So the thresholds suggest intent or recklessness for individuals or consent and connivance for responsible individuals or for an organisation. And we've got quite a lot of written evidence, and some of this suggests that it's setting a very high threshold for accountability, and that the proposed bill should also include negligence or even strict liability for individuals or organisations, or penalising neglect of the part of responsible individuals that we've got in some of the other environmental legislation we've got. So just keen to get views from the witnesses about that issue, about how the bill's drafted, and do you support the approach to liability? Any of you want to come in immediately on that? Shivala, you're nodding your head there. Is that deliberate? Okay, so you're happy with the bill as currently drafted, yes?
No, absolutely not. This is one of the main areas of concern for us. So, as you say, as the bill is currently drafted, the standard of consent or connivance is unusually high for environmental offences, and usually criminal offences in environmental law in Scotland generally apply strict liability as Section 40 of RRA. What we would recommend is having a strict liability offence for relevant organisations as defined in RRA, and have a separate mens rea of consent, connivance or recklessness, which again aligns with the definitions in Section 1 of the bill for relevant officials. And what that means is, most importantly, and I think we'll go on to vicarious liability in a moment, that it excludes workers. Because at the moment, although the intention of the bill, we absolutely appreciate and understand, was to focus on organisations and senior officials, the wording at the moment leaves it too open for workers. So, as we said, a strict liability offence for relevant organisations. That means it becomes a corporate offence, and this addresses also the Scottish Government's question in the memorandum of the difficulty to prove intentional recklessness. And I think the most important bit here is that if the kickback might be, what defence would organisations have? And we would suggest that even with a strict liability offence, there's a limited defence for organisations where they can prove on the balance of probabilities that the harm was caused solely by an unforeseeable external event, such as a sabotage or natural disaster, or outside the scope, or that there was a rogue employee outside their scope of authority. And that kind of balances strict liability with fairness and legal certainty.
Okay, do other witnesses agree with that? Anyone want to come in on this? Yep, Valerie.
I got a lot of reservations about making it a strict liability crime, simply because courts, I think, will not want to impose up to 20 years imprisonment on somebody for strict liability. I think Shivali's got a very good point, maybe split them, strict liability and that. But when you've got, say, a company with a controlling mind and will, being the directors and officers, I don't know how that will work with strict liability on one and then looking at recklessness, intent, etc. on the other. It's a good idea, but I don't know how it would work.
Okay, any of our other witnesses want to come in on that? Sue or Jamie? No? Okay. Going to move to the next question I've got here, which is about how vicarious liability for the acts of employees or agents, separate from acts of directors, etc., who've been at fault. Jamie, you mentioned the Wildlife and Natural Scotland Act. How does that relate to what's in this bill? Are you happy with how it's all set out?
Yes, thank you. I mean, the focus in the Wildlife and Natural Environment Act was much more on the relationship of employer-employee, and the vicarious liability point here obviously makes the same similar provisions, so that it may not be captured by the previous Section 3 of the Ecocide Bill, where you have a corporation or organisation involved. It may be that there's an individual employer, so it's a sort of a double catch, as it were.
So that's good, yes.
We would suggest that it certainly adds strength to the bill, and we would support it.
Okay, that's very helpful. Anyone else want to come in on that issue? I can't see, it's just you still on the screen, Jamie. Oh, perfect.
Shivali's got a hand up, I think.
Okay, Shivali, do you want to come in? I couldn't see that.
Yes, thanks, Sarah. Yes, so I think we've had a lot of conversations with the STUC and Unison trade unions, and also other legal experts on vicarious liability, and goes back to the reasons why we're talking about redefining the bill to have a separate offence for relevant organisations and relevant officials, and we can propose wording for that, which we've already drafted. But the important thing about vicarious liability is, at the moment, it's currently lifted from the Regulatory Reform Act, and it, in our view, does not protect workers, as was the intention of the bill. It merely provides that if an employee or agent has committed ecocide, then the employer can also be charged with ecocide. So the problem, particularly because it's such a high threshold for ecocide, is that we anticipate and are very concerned that in these scenarios, the directors, with all the resources they have, will find lots and lots of areas of wriggle room and loopholes to say, under those three caveats, it wasn't us. That person, that worker, that subcontractor acted without our knowledge, and therefore they should be prosecuted, but not us.
So how would you amend the bill?
So we would amend the bill by making it very clear that only organisations could be culpable, or relevant officials, and not workers. And so we've suggested wording to reflect that, and very clearly it means that none of the above examples of where employee or subcontractor has caused environmental harm can the worker be prosecuted. So none of the above is to confer any liability on the employee, worker, or agent of the relevant organisation. Ecocide can only be committed by responsible officials or relevant organisations. So it's putting in that additional caveat, and including specific provisions should be inserted to protect whistleblowers, because otherwise, as the unions and Professor David White have argued, that there's too many loopholes to leave the employee as the responsible person.
Okay, thank you. And do other panellists agree with Shivali on that issue? Yeah, I don't see anyone coming in. Right, I want to follow on because...
Just before you leave that, Sarah, I think the Deputy Convener just wants to come in on that particular point, if I may.
Thanks. Shivali, just so I understand your explanation around the issue of liability fully, if an employee, in your definition of a worker, and I'm not too sure what how you create that definition, but if they act in such a way and commit an act that, under the definition of this bill, is ecocide, and they are found and the case is proven, who do you, on the basis of what you're trying to redefine the bill as, who should go to prison for 20 years?
So what we're proposing, and I think what's the intention of the bill, is that the person who commits the offence, So, sorry, to answer your first question about who the responsible official is, the bill defines the responsible official very well already. We would actually use the definitions already in the RA. So it's a frontline worker. If they're carrying out the instructions of a responsible official, it's the responsible official who would be liable, and the organisation, because the work has been carrying out instructions. There is.
Excuse me, that's not the question I asked you. What I'm asking you is,
right,
if a worker acts in such a way that results in, on the basis of the definition of this bill, commits genocide, ecocide, who should be sentenced by the courts?
So if a worker is carrying out the instruction that commits that, then it should be the director and the organisation, because there'd be very.
What if they're not acting in that instruction? What if they act in their own way as a worker, they act in their own way and they commit the offence of ecocide as a result? Who should then be sentenced by the courts?
So there is an exception in the definitions that we've given, that if a worker has been rogue and a defence can be inserted by the responsible official or relevant organisation, that they can show on the balance of probabilities that they took all reasonable measures within their power and exercised all due diligence to prevent or to stop all steps, then they would not be liable. But at the moment, that ecocide crime is not relevant to a worker.
Okay.
Just before we go back, I think history has proven that if somebody knows they're doing something wrong, defending yourself by saying that you were only following orders has never been acceptable. And what you're kind of suggesting is that that might be the case. My view is that can't be the case. Surely, Shivali, if you know you're doing wrong and you shouldn't do it. Surely.
I think that's. I don't disagree with you. I think what we're talking about in these examples of acts being perpetrated, that it's never just one person. And I think the way that we are suggesting the amendments to the bill is to ensure that on such a specific act of a genocide or ecocide, we've got the responsibility of the organisation and the directors who take those decisions on those acts.
Okay, I'm going to come back to Sarah. I'm just saying our time is technically up and we have another panel, so you're going to have to be really sharp and snappy on the answers. And I'm sorry if that doesn't give you a chance to explain everything, but it's just the timescales we have. And we do have a stage 2 debate this afternoon, so I don't want to run too late into that. Sarah.
So we've just been talking about organisations and individuals, but what if it's an actual individual that has actually committed this alleged crime? Would it be appropriate to prosecute an individual, for example, a member of the public, who by their actions have created a wildfire that has got absolutely massive consequences that could go on for over a week? We've actually had experiences of that quite recently. Would that be legitimate in this legislation to prosecute somebody if it's reckless behaviour? Valerie, do you want to come in?
I think, yeah. If you've got somebody in a dry forest, has a campsite, walks off and leaves it while it's still burning, and it causes a massive wildfire, destroys homes, destroys habitats, etc. Yeah, why not?
Okay, thank you. That was swift. Other witnesses? Is that a nodding of head? You don't want to come in, Sue?
Yes,
you disagree? Jamie?
If I may comment, thank you. I would agree with that. I think one of the distinctions between the regulatory reform and the ecocide bill is that the test here in ecocide is about recklessness. Well, it's either an intention to cause environmental harm or being reckless. The regulatory reform Act extends to carelessness. So we are dealing with complete disregard of or indifference to the consequences of actions. And the scale of damage that you alluded to, Ms. Boyack, was very significant. Very one. It might tip into severe. It's not for me to make that call, but it's a relevant and recent example.
Okay, thank you very much. Keep it snappy, convener. Yes.
Thank you. Thanks, Sarah. It's nothing like being told what to do as convener by a committee member. Reference those later questions that you wanted. No. Now, just to make it clear, when I talked about a river earlier, I wasn't referring to the River Spey, of course, because if I did, I would have had to declare an interest. But if you think that I was, I do have an interest in the River Spey. So let's go on to the penalties. 20 years in prison and an unlimited fine. Massive. Required, yes or no? Jamie?
Yes, I would submit, convener, that it is important to have severe fines to really hammer the point home.
Okay. Does anyone think that they're too strong? No, you're all thinking that 20 years in prison is the right place to be for somebody who does this.
Mr. Convener, if I may add, if it's an order, it will obviously be at the discretion of the court in their sentencing. So it's not 20 years or nothing. It's not exceeding 20 years. So
up to 20 years and an unlimited fine. I take that point. Now, the other question is somebody suggested linking fines rather than just saying unlimited fines, or some people have suggested in the consultation that it should be linked to turnover. Would that be a good way of doing it? In the same way, say, for example, I think they can link some speeding fines to income as well. So should it be linked to income? Yes? No? Anyone against doing that? Might be a good amendment. Yes? Okay, no one's against that. Thank you. And I was snappy, and I'm now moving straight to Mark for your next questions.
Can I
You're
just
in
ask
trouble.
you, I think some of you may have already covered this already, but do you think the bill is necessary for alignment of the EU Environmental Crime Directive? Valerie, do you want to?
I'm sorry, can you repeat that?
Do you think that
Sorry.
the bill is necessary for alignment with the EU Environmental Crime Directive?
Yes.
Okay. Sue? Yeah, okay. Jamie?
yes, yes.
Yeah, Shefali?
Yes.
Okay. And I think we've also, we've looked at the examples of how other countries have introduced ecocide. Are there any other lessons from or examples that you feel it's relevant at this point to raise in relation to how those have rolled out that would be pertinent to Scotland? Any other lessons we can learn from how those laws have been introduced to date? Sue, you're operating internationally. You must have some views on that.
I think, thinking about lessons from ecocide, but because it's so early, there's very little evidence to sort of to present to the committee. But one thing I would like to say, I don't know if that now is the appropriate time, is that it protects the precautionary principle. And I think that's a really important aspect of it. And I can say something about it now, or I've done it as a request to speak. Is it something that the committee would like to hear about?
Briefly, that would be excellent. Yep. Mm-hmm.
Yep. So at the moment, we've got a lot of new technologies unfolding and being sort of released into the world. And we know that regulation is always playing catch up with these new technologies. And we've got things that purport to be, you can see it's happening with social media, it's happening with artificial intelligence, and there's this fear, but the regulation is struggling to catch up. So a lot of these new technologies are about protecting the environment. So things like solar radiation modification, synthetic biology, that sort of thing, untested. So if you've got ecocide in place, you've already got a safe space, in a sense, for these technologies to roll out into, and it protects the precautionary principle. So until the regulation has a chance to catch up, there is a space, and it means that much more due diligence will need to be done before these technologies are released into the world. So that was my little piece on.
That's a useful point, and I'm assuming because the precautionary principle is embedded into EU law, then that effectively is a way for states to maintain alignment through adopting ecocide. Is that your point?
I don't know if they've got it that specifically. So I think it does create that safe space. I'm not sure if it's specific in that sense. I'd have to go back to you. I have to get back to you on that. But in terms of general principles, if you're releasing something into the world and it creates the sort of damage that would qualify as ecocide, then you're putting yourself into, a dangerous situation. And I think it would act as a very strong safeguard in terms of new technologies.
Okay. If there aren't any further reflections on that, then I'll move back to the convener. Oh no, Jamie, I think you want in.
Yes, thank you, Mr. Russell. Just adding on to Sue's point there, in terms of the precautionary principle, there's also a key guiding principle on the environment, the preventative principle, and both of those are embedded in the UK withdrawal from the European Union Continuity Scotland Act that we have as part of our exit from Europe. So that's sort of enshrined within Scots law.
Yeah, thanks.
Thanks. And now we're going to come at last to Douglas, who's kept very quiet during the whole thing. You've got some questions.
Thank you, Convener, and I'll be quick as well. Moving on to enforcement now. Just want to ask, so is Section 9 of the Bill, extending enforcement powers in relation to ecocides, sufficient to ensure the relevant authorities have the power to investigate a potential offence? Can I maybe come to Jamie, first of all, on that, if he has a view?
I don't have a specific view on that. Indeed, in our submission to in our written submission, we didn't pick up on that specifically, in that we don't have any proposed suggestions to that section of the proposed bill.
Anybody else got a view on that, or it might be really quick, Convener?
Her questions.
I'll ask one thing on enforcement. We've heard earlier, organisations like SEPA are really up against it in terms of resource. So how would this, given them even more powers, how would this help SEPA when they've got already struggling for resource?
Wanted to come in on the point. You may. Did you want to come in? Did I?
No.
Oh, okay.
No,
I
no.
apologise. Sorry, Douglas.
So yeah, it was just really, if SEPA are already struggling for resource, how will giving them this extra powers, how will that help them with that resource issue they have? No. Okay, I'll ask one little other slight question. I'm trying to understand, let's say if an incident happened in Scotland, the organisation's HQ was, well, let's say in Carlisle, for example, how would the law work, the proposed law work on when the organisation is headquartered somewhere else? Maybe Jamie, in terms of a Law Society of Scotland view, how would that be handled?
Well, I would suggest that if the crime takes place in Scotland, then even if it were a foreign or a company out with Scotland that had been responsible, then they could still be prosecuted in Scotland. So Scotland would be the jurisdiction where the prosecution would take place regardless of nationality.
Okay, so let's say the organisation was based in the States. So there would have to be some sort of, how would that, the 20-year penalty, for example, on a US company be enforced? Would there have to be some sort of agreement to get that individual back to a court in Scotland? How would it work?
I need to pass on that, but I can come back in writing more fully, Ms Lumsden.
Does anybody else have a view on how it would work cross-border? No. Okay, thanks.
Monica, a couple of questions for you, if you want to pose them to any of the witnesses.
Thank you, Convener, for the opportunity, and thank you to our witnesses today. I think it's been encouraging to hear the broad support for the principles, and many of the points raised are matters that I gave careful consideration to in terms of drafting options, but very struck by the discussion and the questions around just how we get the wording and the terms correct and proportionate in terms of culpability, liability, defensive necessity, encouraged also by the Scottish Government's memorandum to the committee, and I hope that witnesses have had a chance to look at that as well. That might allay some of the fears that my colleague Kevin Stewart has about the timing of this bill, but I have been reminded that a number of bills were completed in the final week of Parliament last year, so we do have quite a bit of time still in hand. But in terms of what stage 2 amendments could look like, Dr Shivali-Fifield, you've obviously been working on some suggested wording, and it would be good to see that. I'm certainly open to what amendments could look like, but just this issue about responsibility should an ecocide crime occur. I'm sympathetic to the concerns about undue pressure on workers, a risk of coercion, and I guess what I think you're trying to say, Dr Fifield, is that there could be responsibility shoved down to workers when people at the top of an organisation try to get off scot-free. But how could an ecocide bill and the communications around it lift everyone's awareness of taking responsibility so that we can achieve the aims around the bill, which is about preventing ecocide harm from occurring in the first place? Keen to hear from Dr Shivali, but if anyone else has a comment on that, that would be helpful.
Yeah, thank you, Monica. I mean, I think we've already talked, haven't we, that to what extent having an ecocide bill would increase awareness and understanding within organisations to improve practice and perhaps also encourage a wider culture of reforming permits and wider environmental governance issues, as Jamie's already talked about. So I think there is something, Monica, about that positive culture and that positive change. I think as it stands, as I said already, and the conversations I've had with unions, the vicarious liability is too open. I think there is things we can propose to make it tighter so that workers are not scapegoated. The point that Ms Boyack raised with me about individuals committing significant environmental harm, I think we must also remember that we have the other suite of environmental laws that should address that as well. So this is the ecocide level crime, and with individual acts with the existing environmental laws such as RA, Wildlife and Crime Act, etc., we should be able to address individual misdemeanours under those pieces of legislation. I think that what we can do, Monica, with the vicarious liability is just to make sure that this bill, as intended, was for a corporate offence at the highest threshold, and that would be in line with the EU directive as well. I don't know if there's anything else
Thank
that
you.
you'd like me to follow up on.
Would anyone else like to add to that? No.
For a second question, I'm just conscious of the time.
Yeah, final question then, convener, because keen to hear from the second panel also. We know that in terms of the EU, the Environmental Crime Directive has become quite well established. I think it's May of next year when that has to fully come into effect for the member states of the EU. What could potential risks be if Scotland doesn't criminalise ecocide? Could get there eventually, but what could the attitude be to doing business in Scotland if we don't keep pace with the EU and our other jurisdictions on this matter? Perhaps Sue maybe could respond on that first.
Well, I guess there will be a mismatch of expectations and sort of regulations in terms of the business carried out with the EU. So I think that's probably the primary thing. And also, Scotland's stated objective to keep pace with the EU, I think, is important here. So I think that's probably the primary issues there. But obviously, in terms of ongoing sort of trade, commerce, dealings with the EU, you want to keep in lockstep, and there's a danger of falling out of sync.
Thank you.
I'd just like to second that, really. The Environmental Crime Directive is major legislation. It went through unbelievable amount of time to put that together, unbelievable amount of amendments, and a lot of those amendments were focused on ecocide. So I think, yeah, it would be a real shame for Scotland to fall out of sync with that.
Thank you. Thank you, convener.
Thank you. And I want to thank the panel this morning for coming in and giving evidence. I apologise for making you answer more questions and for stay longer than the thing. But maybe that's because you gave some very detailed answers. So I'm going to let you shoulder some of the blame. But thank you very much. And I think some of you have offered to submit information to the committee afterwards. The sooner you can do that, the better, because there are pressures on our timescale to get answers for this and other things we're dealing with. So I'm now going to suspend the meeting till 10:40. So I'll suspend the meeting. Okay, welcome back, everyone. We now turn to our second panel of witnesses on the Ecoside Scotland Bill. And I welcome to the meeting Catherine McWilliam, Nations Director Scotland at the Institute of Directors, Professor Simon Parsons, Director of Environmental Planning and Assurance at Scottish Water, Elspeth MacDonald, Chief Executive. I don't know if I was probably promoting you. Chief Executive Officer at the Scottish Fishermen's Federation, and Johnny Hall, the Deputy Chief Executive Officer and Director of Policy at the National Farmers Union. Thank you all for attending. And you will have seen at the end of the last session that I was trying to keep people moving because of time-wise, and I apologise that I've kept you waiting. It's something I don't like doing, and I don't like to have to apologise for, but I hope you'll accept my apologies. So, my first question is a simple yes, no, just to warm you up on how the rest of the answers go. Is a new offence of ecocide needed in Scotland? And I'm going to start on my left, your right. Johnny, yes or no?
No.
Elspeth?
No.
Simon?
No.
Catherine?
I'm not going to be able to give a yes or a no specifically because I think because of the nature of the IOD, some of our members will sit on either side of the argument. So I would say principle commendable, but we need to have more guidance.
Okay, thank you. My next question is based on that. Do you think there is a significant risk of an ecocide event happening in Scotland as defined within the bill? And we'll start the other way around. Catherine?
Again, I would refer back to my previous answer. We'd be looking for more clarity and guidance around some of the the terms as outlined in the bill, which again we'll probably get into as we discuss today.
It sounds like the Fifth Amendment. Simon?
I'll be taking the same approach. I think we need to understand really what would actually lead to a conviction under the proposed ecocide bill to understand that really. But it sounds a lot of it is around intent. So it would be important to understand what do we mean by intent to cause these incidents, for example.
Elspeth?
Yeah, I think there's lots of clarification that is needed. I think, certainly, I'm not a lawyer. My reading of the bill as drafted makes me think that there's lots of things that could fall into the criteria as set out in the bill for ecocide. So I think that's why this type of discussion and the clarification that we need to have around the intent of the bill and what will be captured by it is extremely important.
And Johnny?
Yeah, just to echo my fellow panellists, I think there's a significant amount of work still required in terms of defining phrases such as intent, long-lasting, widespread, etc., particularly in a farming context where you're talking about multiple, 17,500 to be exact, agricultural businesses operating within Scotland on different scales and different sizes. So things like that all of a sudden become very important in terms of what would constitute an ecocide event. And I also couch that, and I'm sure we'll get to this discussion, in the context of the existing regulatory framework that is there to prevent environmental damage. And I'm sure we'll come on to some of the discussion around that.
Okay, and finally, and I was going to say you'd all done so well, and then Johnny blew it by more than a sentence or two. But let's see if I can just push this. Do we think that making ecocide a criminal offence is the way forward? Start in the middle and work outwards. So that's going to be Elspeth first.
I think as ecocide is defined here, I have very serious concerns about making it a criminal offence as it is defined in this bill.
Simon, Johnny, let's go to Johnny and then...
If ecocide and the intent here is to prevent environmental damage of any sort, then I think, as I've already alluded to, there are significant safeguards in place and there are significant measures already in place to deter that. So I don't think an ecocide bill is necessary.
Catherine.
Similar to comments that colleagues have already made, our concerns relate more to the unintended consequences and maybe some of the indirect consequences as a result of it being a criminal offence. I think particularly for the SME community and the cumulative burden of other regulation would be an area that we would be concerned.
Okay. Simon.
Yeah, so we have a very strong environmental regulations already in Scotland, and they work on a mixture of deterrence and support. And I'm not sure deterrence and greater deterrence is really the best route to get environmental improvements.
Okay. I'm going to move on to the next questions, but I probably should have done this at the beginning, just to clarify. And I know the committee get bored of doing this, but I suspect, as Johnny's going to talk a bit about agriculture, I should just remind committee members that I'm a member of a family farming partnership in Murray, but I should also make clear that I'm not a member of the NFUS. So that's my declaration out of the way. Sarah, over to you.
Thanks very much, Convener. I just want to ask the panellists, do you agree with the definition of ecocide? Is it clear to you what kind of and what level of environmental harms are being targeted by the bill? Or do you think that could be made more clear? Who would like to kick off? Are you happy with it, or you got issues? Right, Catherine.
I'm happy to go first. I mean, one of our kind of, just to kind of set the context, Institute of Directors, as the committee will be aware, cross-sector, cross-industry organisation of kind of leaders and decision makers right across Scotland. And again, just to kind of go back to my earlier comment, it's very difficult for us to kind of land on one side or another, given the nature of our members. But with that in mind, we had a conversation with some of our ambassadors who work across the sustainability space. And what is very clear is that definition and terminology is going to be critically important here, because right now it does feel that there are certain elements that are open to interpretation. We accept that that will come through in kind of guidance notes, but it's absolutely critical that these are clear. And we do have questions around the kind of practical implementation as currently defined, particularly from a boardroom point of view, and kind of questions that non-executive directors are going to be asking, given that a lot of non-exec directors are maybe kind of experienced in certain areas but not others. How do we make this easy for people to not fall into traps?
Okay. Anyone else want to come in on the issue? But definition?
I mean, I think if I look at the definition, you have substantial likelihood of severe and widespread long-term damage to the environment. I think we all can understand that to a degree. It's what does that actually mean? What constitutes widespread? What constitutes long-lasting, for example? And it would be the rules and the guidance that goes around it, which would be very important to organisations like ourselves.
And is that about the definition in the bill on the face of it, or is that about guidance for you?
I think at the moment, if I'm reading the definition as it's written here, I think we can probably all understand the scale of an ecocide issue, but we would need some guidance as to what does each of these terms actually mean, and how would that relate to us as an organisation, for example.
That's very useful, thanks. Other witnesses? Johnny, do you want to
Yeah, I think in the bill itself, there is a wee bit of guidance in terms of geographical spread, impact on species or habitats, in terms of that widespread nature. The long-lasting element of it is in part 1 of the bill. But nevertheless, I think, as alluded to already, more clear, more in-depth guidance is absolutely required as to how ecocide is interpreted, and therefore what might constitute a crime if it is to be a criminal act if ecocide is committed.
Okay, thank you. And Elizabeth?
I think very much agree with my colleagues there in terms of I think there is not sufficient clarity in the bill as it stands in terms of the definition of ecocide. I think also there is not any clarity about what is not ecocide. So I would be concerned about the definition as it currently stands, to my reading, capturing a number of legitimate regulated activities that may nonetheless have environmental harm that is could be widespread and could be long-term. And these could be a wide range of things, building new roads, building offshore wind farms, all sorts of things. So I think we need much greater clarity around the definition of what is and also what is not ecocide. Thank you.
Okay. That was quite succinct from everybody. That's really good. Could you give us your views about whether the definition of ecocide in the bill should apply to environmental harm caused cumulatively as a result of course of conduct or ongoing activity versus a one-off single emergency type incident? So just wondering how you think that would impact on different types of industries or economic activity across the country. You've already mentioned some forms of economic activity that potentially could be included. So do you want to expand a little bit more on that?
Yeah, I'm certainly concerned about the possibility of cumulative impact of legitimate, regulated, legal activity being considered as ecocide. And I think that touches also on a sort of wider point around ecocide that as I've been sort of reading into this subject matter, looking at various academic articles, etc., that talk around, much of what is the significant environmental harm that our world faces is actually caused by cumulative activities of all of us, all of the things that we do as we go about our day-to-day life, whether that's getting on a plane to go on holiday or all sorts of activities. So I think there needs to be greater clarity, I think, if this bill is to progress, between these one-off emergency major incident type events and that cumulative impact of lots of different people undertaking lots of different perfectly legal and legitimate and in many cases regulated activities. I think that's a really important distinction that needs to be made, and I don't think that comes through in the bill.
Okay, and would you like to come in, Johnny? I'm thinking particularly about the use of natural resources or food production by Scottish businesses.
Yeah, I mean, clearly the long-term implications are vitally important. We live in a world now where, certainly in an agricultural context, where we must deliver on our sustainability agenda, and certainly the term regenerative, if I can say it, is very much part of the agenda that certainly Scottish agriculture is being asked and will deliver on. And therefore, you're talking about time horizons whereby things could accumulate over different time frames. I think there is a difference, though, here, if you're talking about specific events in an ecocide context as being one-off. I would almost draw a parallel with the difference between point source pollution and diffuse pollution, in the sense that you can identify a significant event happening that might cause a consequence versus things that might accrue over time because of ongoing practice, which, as Elspeth has already alluded to, is already well governed and documented. But as we sit here today, we might not know what the ultimate environmental impact of today's activities might be in the future. And people operating today in an agricultural context or another context might be doing so within the regulations and in good faith, but at some point somebody might say, actually, over time this has created an environmental impact that we didn't appreciate, and therefore is that going to be a criminal offence? I think there's a very distinct difference between the two things of being a one-off today event versus something that might happen over time, and therefore I think we need to tread very carefully about differentiating between the two.
Okay, thank you.
I mean, 100% agree with what colleagues are saying there. The idea that, I think we could probably also understand an individual event that causes a very widespread impact as part of that. On that one, but a continuation of activities that maybe we are licensed to do, for example. We're licensed to extract from the environment, we're licensed to discharge to the environment. If we're compliant with those licenses and in X years' time we think they are no longer the right activities, it would be very difficult to understand why we would be prosecuted for that. And I think a really good example is something that we are all working with in society at the moment is PFAS, if you've heard of PFAS. So this is something that 10 years ago was viewed as something that was good. It's now widespread across the environment. But yeah, we all have probably at some point in our last 10 years bought something that contains PFAS. It's now widespread in the environment.
I have no idea what that means.
Oh, okay.
So could you explain it to me very briefly?
Yeah, so these are a series of chemicals. So Teflon, it's on waterproof coatings you use. It's called the forever chemicals because they don't degrade in the environment. They have been a very widespread use across the world. We now have standards, for example, in our drinking water here in the UK. In Scotland, for example, we had it well ahead of the rest of the UK, which is about protecting to make sure the glasses of water you have, when you use water in your home, that actually there's no pollution from the PFAS in there. But we find it in water sources all across Scotland, for example, whether it be Fair Isle or here in Edinburgh, we'll find that PFAS in there. So it's a chemical that we've all used for many, many years, thinking it was a good thing. It's now widespread in the environment, and we don't quite know how to get it out.
Okay, so my frying pan's bad for two reasons. Sorry, okay, back to you, sir.
Yeah, so presumably this partly comes down to risk assessment as well. And Catherine, in terms of your feedback on this issue, what are your thoughts?
I mean, I will give a very specific example right now about where this is really important when we overlay it with other initiatives or projects that are taking place. Take, for example, my members in the Highlands and Islands. They're all, very rurally located. They are actively campaigning for things like the upgrade to the A9 so that they can, get more people into the area who come to appreciate it for its natural beauty. There you go, you have that kind of first conflict. But when we are talking about things like, massive diversions with the North Coast 500 route just now, again, it comes back to that interpretation and what actually does, what do we mean by ecocide in that context when we're trying to encourage more people to a beautiful region in Scotland, but in order to get them there, we need the infrastructure in place and the amenities to support that.
Okay. Anyone else got to come in on that issue? No? Hand it back to Convener.
Sorry, I know Bob wants to come in. I just want to push on one little thing here is under the offence of ecocide, it says for the purpose of this section, environmental harm, long term if it's irreversible or unlikely to be reversed through a process of natural recovery within 12 months. It might be that something can be done to speed up the process, but it's not natural, and therefore, or the recovery process. So it would still be ecocide, although somebody's done everything in their power to reverse an unfortunate event. Are you comfortable with that?
Convener, we have that principle already established under cross-compliance in relation to agricultural support payments. That if there is a breach of one of those cross-compliance requirements, not all of them, but some of them, that farmer or crofter does have up to 12 months to reverse that. So it removes the permanence element. I guess in this context of the ecocide bill, it relates that it is not long-lasting. So if something can be reversed, then it's deemed to be, there might be a penalty attached in relation to those support payments, but it will not result in further punishment if it can be reversed.
Yeah, but my understanding of that is they can take action themselves.
Yes, yeah.
Whereas this says it is a process of natural recovery,
well, in that
which
sense,
it confirms that they can't do anything. If nature can't do it, it's got to be ecocide.
Well, I think that's a very short-term and very myopic view in terms of if you can intervene to rectify an issue, then that should be an option.
Okay. I see nods. Bob, you wanted to come in.
It was on the exact same bit, but no, that's fine, but it maybe shows that there's something in that. I was just wondering whether 12 months was always a realistic recovery time period. It must be determined in what instant or event has happened. But the natural cycle of things may mean that 18 to 24 months is about a recovery plan that's put in place, that's robust and evidence-based rather than a cliff edge of 12 months. Any comments in relation to that, Johnny Hall?
Yeah, I would agree. The 12 months and indeed the whole cross-compliance framework that Scottish agriculture currently operates to is a legacy of being part of Europe and under the Common Agricultural Policy. So I suspect it would be within the gift of the Scottish Government and the Scottish Parliament to actually change that requirement if that would be deemed to be the right thing to do. But we operate under EU retained law in many, many respects around the environment, and not least in an agricultural context. So that 12 months is just a hangover, if you like, from the Common Agricultural Policy and the cross-compliance from Europe. But I'm not saying it's necessarily right. We could look at extending that. If we were to go down more of a natural approach, it may well need time for certain issues to recover, rather than going in with a more interventionist approach to hasten that recovery.
Okay, I suppose Elspeth will absolutely bring in. My point wasn't that we should ditch 12 months. It's about nuance and light and shade, and whether there would be examples where a derogation would be reasonable rather than ditching it altogether. Elspeth MacDonald.
Yeah, I think it's a very arbitrary time limit, and I think the time limit for recovery, whether that's natural recovery or human-enhanced recovery, I think really surely will depend on the nature of the harm, because some types of environmental harm might be quite quick to be able to restore them, others might be much slower. So I think it's very difficult to pick an arbitrary figure and say that that should be the definition of long-term for all types of harm that might be captured under this bill.
Okay, and again, because of time constraints, I won't explore that further, but the final comment on definition, convener, was in the last session, and this doesn't mean I disagree with the policy intent of any of this. It means I think there might be for clarity, but I think with witnesses pretty much all agree that if an individual leaves a barbecue in an open area and it leads to a forest fire and there's significant damage, that would be seen as an ecocide event. But we also heard in the same session that the policy intent was also to make a corporate offence at the very highest level. There seems to be, a forest fire is an event at a very serious high level, but it doesn't necessarily mean it's a corporate offence. Is there a blur around what the intention of this is for? Because we can't have barbecue fires and then a corporate offence at highest level. There seems to be a kind of, that rubs against each other a little bit. I don't know if you heard that in the last session. Any comments in relation to that?
It's unclear. Yeah. I think it is not clear exactly what ecocide would be, as in the bill that's drafted.
Okay,
I would agree. I think it'd be really important is in terms of whether or not the barbecue fire example is actually going to meet what's a very, very high bar in terms of the definition of ecocide compared to other crimes, for example. I wouldn't have necessarily, when I walked in here today, would have thought that a barbecue fire was going to be one of the potential would be considered ecocide.
Maybe I've picked the last evidence session wrong, but it's just that a lack of clarity rather than a flaw within the bill. But I just wanted to draw that to your attention. Thank you. So
to me, the big part of the bill is around intent, and wanton intent, I think, is some of the phrases that you're just reacting. Mr. Doris, to your comment there, to me that seems like a very different crime to probably what I would have perceived as would have been hitting the bar for ecocide.
Okay, thank you. Thank you.
Just to clarify, I think what the word wanton intent was taken out when it came to think. Mark.
Johnny, you were saying earlier on about making a distinction between a catastrophic event, effectively like a point source pollution, and then those longer term practices that over time might degrade the environment, and we might not know about those until it's too late. I mean, can you point to particular risks around ecocide within each of your sectors, or are you saying that you don't see ecocide applying at all to your sectors, and you're more concerned about a wider definition that could capture, long-term management of farms and the seas and Scottish water assets that could be captured by this over time? I mean, are there other examples in farming where you could clearly say pollution incident, hundreds of tons of slurry going into a river, killing off a river, that could be ecocide?
But that's already governed by regulations that SEPA enforce. So that's the point I really would like to make, is that there is a whole raft of environmental regulations, not just in relation to cross-compliance relating to agricultural support payments and grants, etc., but actual laws of the land that already exist, which SEPA enforce around exactly what you've just said, around if there was a point source pollution whereby slurry escaped into a water course and polluted the water course and whatever it might be. And there are other things around that sort of more widespread prevention of agricultural damage in relation to what farmers and crofters are allowed and not allowed to do in order to safeguard our environment. And at the end of the day, the agricultural sector and the food and drink sector of Scotland actually utilises and needs to utilise its environmental credentials as the unique selling point in many ways of what Scottish agriculture produces and what the food sector delivers. So having that integrity backed by a degree of regulation as well as around the things like farm assurance is critical. So I believe that there is I could list a whole catalogue, as I say, of things that already exist that require farmers and crofters to prevent agricultural pollution. We have something called the PEPFAR code, and the first P in PEPFAR stands for prevention. So and there's various pieces of legislation behind that. And therefore, where an incident happens, SEPA have the capacity to issue penalties or indeed take the more extreme cases to court and then to be prosecuted.
Yeah. So as a highly regulated sector where prevention comes first, what is the concern about ecocide? Simon, what would be your concern from the water industry? Because it seems inconceivable, right, that there could be ecocide. So what is the concern about adopting it? So if you think it doesn't apply to your sectors?
Yeah. So first of all, I think we, just as John has just described there, we've benefited. Scottish Water are hugely dependent on a healthy environment for the water we take and the discharges we put back into the environment. So, and we've benefited from a very strong and collaborative kind of regulation approach here in Scotland with SEPA and other bodies as part of that. So to me, the regulations we already have are successful. They're working in a way that encourages us to be better every year that we do. But also, if we are not, and if there is incidences where we aren't good enough, there are penalties that with SEPA in particular, will put forward to us. We also already have regulations which are around significant environmental harm. So the key issue here is this is about the next level up on top of significant environmental harm. So will it lead to a change, for example, on how we manage our abstractions or manage our reservoirs or manage our discharges to the environment? I don't think there's anything in this bill at the moment that would lead to that.
So what's the concern then?
So more regulation.
You just say it doesn't have any impact because you're already highly regulated. So I'm just not sure from your sectors what the concern is. Elspeth, do you want...
Yeah, again, my sector is highly regulated. Again, Johnny's made up of a large number of small businesses, from very small ones to bigger ones, but largely within the definition of SMEs. Highly regulated sector, lots of sector-specific legislation. My concern about this bill is that I'm not clear, and as I say, I am not a legally qualified person, and perhaps I can be better informed by somebody who is, but I'm not clear that things that might be legitimately undertaken by people in my industry couldn't be captured by some of the definitions in this bill, and that's what I would like clarification and further information on. I think there may be... We've all spoken about the fact that we are in heavily regulated sectors. There possibly are issues around, just how well is all of that legislation being enforced. Perhaps that's something that also needs to be something that the committee and parliamentarians might want to consider as this bill goes forward, because we already have a lot of legislation, and adding another layer into that, if the existing layers are not being adequately resourced or being adequately taken forward, then perhaps that's a way of addressing some of the concerns that might lie behind the bill. I think I think it's really important to recognise that, certainly from the perspective of Johnny and I, we are food producers. We are in the business of producing food. That is a public good. And I think it's also important that people understand that you can't have any type of food production without there being some kind of impact of that. What we don't want this bill to inadvertently do is capture within ecocide, within the definition of ecocide, the cumulative impact of legitimate regulated activities.
Okay. Catherine, were there particular sectors within your membership that who have a particular concern, or are they all saying, well, no, it's fine, we're regulated, we don't see a threat here, but we just don't like the idea of ecocide and what it could turn into?
There is an element, again, and I mean, some of those sectors have been covered by colleagues, but I think from our point of view, taking a more kind of general approach, looking at SMEs and particularly micro SMEs, there's a proportionality element to kind of penalties imposed. And again, it comes back to kind of the understanding of the terminology and the definitions included within the bill. We don't have specific feedback from any specific sector, but that's something that I think over time we could look to gather.
Okay, thanks.
I think the Deputy Convener wants to come in, and then we'll move to Kevin for his questions.
Thanks, Convener. I think I hear from some of you that you feel that this bill isn't necessary, and that some of you are seeking some further guidance and explanation around provisions within the bill. I think it's worth reflecting the fact is that this is not a regulation-making bill. This is a bill which is creating a criminal offence. Guidance and explanatory notes associated with it will only take you so far, because the real definition will be set by the courts, and some of those terms will be defined by the courts if enacted and taken forward. Can I therefore ask, is it your contention that the existing regulatory framework to deal with environmental offences is sufficient? If it's not sufficient, then where do you think the gaps are that need to be addressed that would then mean that this bill is unnecessary? Can I come to you, Johnny?
Yes, my immediate reaction to that is that I think the existing regulatory framework, certainly in an agricultural and a land use context, is sufficient. I can't think of a particular environmental event relating to agricultural land use that is not or potentially not covered by existing regulation, and therefore there would be recourse for authorities, whether it be SEPA or Scottish Government itself through the Rural Payments and Inspectorate Division, to actually take action where necessary.
Okay. Elspeth?
Yeah, I would agree. I believe that we have an extensive raft of legislation that regulates our sector that I think is capable of dealing with illegal activity, is capable of dealing with the types of offences that might be carried out, the harms that might be caused. I think I'm casting my mind back too to when I read the policy memorandum of the bill, and my recollection was that it doesn't actually it didn't for me set out evidence of why the bill is needed. It talked quite a lot about beliefs around ecocide, thoughts around and feelings around environmental protection, which are all extremely important and, of course, are valid. But is that does that meet the benchmark, if you like, or does that meet the test for saying, let us make this a criminal offence? Because I do not recall seeing evidence setting out for why Scotland needs an ecocide bill in the policy memorandum for this bill.
Okay. Simon?
Yeah, I agree. I mean, we have a very strong regulatory framework here in Scotland. So I'd agree that, if I try and think about what incidents would happen that would lead to an ecocide criminal case, for example, as part of that, do I see anything that wouldn't be covered by existing regulations? And if I think about abstractions, about management of reservoirs or discharges in the environment for us, I don't see anything that wouldn't be covered by existing regulations. I think there is something in terms of if the offence part of it is linked to us being grossly irresponsible or deliberate behaviour, again, I would see that be captured as part of us as a corporate in terms of our licences and how we interact with organisations like SEPA. So at the moment, I can't see what add having as a criminal impact would have over our current regulations.
Okay. Catherine?
I am far less of an expert in environmental regulation than my colleagues, so can only kind of give a kind of, I suppose, a general response to that question. I think from my members' point of view, what we hear consistently is people get the what and the why around a lot of the regulation that we have in Scotland. A lot of the difficulty comes with the how, and it's support and guidance and resource to implement that. It's not necessarily about the funding or the money, it's just where people get the, the case studies and the best practice advice. So I think it could come down to something like how we are working with existing regulators to look at how we communicate what needs to be done and how it can be done across a variety of different sectors.
Okay, thanks, Convener.
Thank you, Michael. Kevin, over to you.
Thank you very much, Convener, and good morning. Some of you have kind of already answered this, but I'd like, for the record, a yes or no answer, please. Is it clear to you how the bill would interact with existing environmental legislation and regulation? Catherine?
Not currently.
Simon, please.
No.
Elspeth?
No.
No.
Johnny? Quite clear there in all of that. We talked with the earlier panel around about some of the existing legislation and regulation, particularly around about Section 40 of the Regulatory Reform Scotland Act 2014, and we also talked about how the bill could possibly interact with environmental liability regulations. The conversation then drifted on to permits and licensing. And some of you have already said that, maybe reviewing licensing or permissions are required rather than this overarching bill. Do you have comments about Section 40 of the Regulatory Reform Act, and what do you think about permits and licensing? Catherine, please.
That's not an area I have any expertise on at all.
Fine, thank you. Simon, please.
Yeah, so obviously that Act's been with us for a while in terms of doing that. I think the differences that I see here is around the definition of severe versus significant harm. So we already have regulation about significant harm that are part of those regulations that we already have. For Scottish Water, we're very reliant on SEPA setting those permits or licences, and our job is then to meet those licences because SEPA have determined what the environmental capacity of, say, of a water source is or a discharge point would be. So our role is very much about making sure that we're compliant with those licences and permits. And again, having a programme of making sure they're updated, refreshed, fit for current regulations, for example, would make sense as part of that activity. But at the moment, the framework we have about organisations like us, if we want to discharge or take from the environment, that they are managed with permits and licences works.
So updating those permits and licences would be the priority, to take into account things like the forever chemicals that you mentioned earlier?
Forever chemicals, or probably the biggest challenge we face at the moment is climate change. How are we adapting our operations to climate change? And we've seen it very much this year across much of the east of Scotland in terms of water shortages, for example, or where we've had extended periods of dry weather.
Okay, thank you. Elspeth, please.
Yeah, thank you. Like Catherine, I do not have any specific expertise around Section 40 of the our Regulatory Reform Act, so I do not consider myself well qualified to speak to that. My industry is a licensable activity. Fishing vessels have to be licensed before they can go commercially catch fish. It's not one where permits are involved, and licensing is carried out in a rather different way under fisheries legislation. But I think the way in which existing legislation interacts should be sufficient to allow us to use those systems to manage businesses and to look at those businesses that are compliant and those businesses who aren't. I think a point that I also wanted to make, perhaps it was slightly more relevant to the last question from the Deputy Convener, but I think too the background information about the bill talks about a review currently underway by the Scottish Sentencing Council, looking at penalties and sanctions on wildlife and environmental legislation, and I think that too is maybe pertinent to what we're talking about today. how effective is the existing law in dealing with environmental harm, and how much is there a need to do anything more?
Thank you. Johnny, please.
Yeah, again, I wouldn't go into the regulatory detail of Section 40, but I do know that in terms of particularly the water environment and how agriculture interfaces with the water environment, we have a cascade all the way back to the Water Framework Directive from Europe. This place passed something called the Water Environment Water Services Act Scotland back in about 2002, something like that. And ever since then, we've had a raft of regulatory frameworks which have created, for SEPA, in effect, a licensing regime whereby you have, on the one hand, for light touch activities, something called general binding rules. But as the interventions or actions or activities go up a further scale, you're then talking about authorizations at one level, and then you're talking about licenses. So all that is currently in place. Now, that's not to say it should be fixed forevermore. We would argue that actually some of that needs to be reviewed, just as Simon said about the fact that changing circumstances and so on. But there is clearly a place for having a regulatory regime which is governed, if you like, by elements of authorization, licensing, call it what you want. And I think that's vitally important. And in other contexts, very, very quickly, we have something called the Environmental Impact Assessment, open brackets, agriculture regulations in Scotland, which means that farmers and crofters can't just go onto the land, drain it, plough it, do whatever they like. They have to get prior notification for all these sorts of things. And that exists. And therefore, I think there's that element, as I've said a few times this morning, there's that element of, with a focus on prevention rather than anything else. And we'd be the first to say, if somebody overrides that, ignores that, and just goes in and intentionally does something to the environment which they have some sort of responsibility over, then I would say throw the book at them. But that book already exists. SEPA already has powers to take individuals to court, to impose fines, whatever. But that is such a rare event in certainly our industry. Everybody operates within a regulatory framework, and they understand that and the reasons why.
So one of the things that has been said about the Regulatory Reform Act is that there have been very few prosecutions. Is that, in your opinion, because people are adhering to the legislation and the regulation that is already there?
Can I just
please
on that? Certainly in the interface between SEPA and farming, and crofting, I think SEPA have been incredibly well engaged with the farming community, in particular priority catchment areas and so on. And they've recognised the fact that actually there is no criminal intent on behalf of farmers and crofters to cause environmental damage. Environmental damage can occur through a lack of awareness, confusion, a degree of non-compliance. In those situations, it's far more important that we actually educate and change and guide individuals to do the right thing rather than necessarily take them to court. But where there are cases where people have clearly ridden roughshod over the requirements that they should be adhering to, fixed penalty notices are served and occasionally they do go to court. So I think it's a case of actually looking at it in context and saying, just because an environmental incident happens, is it about the intent? And I guess that's where the concern here is.
So one of the previous panel members said, and I paraphrase, that the bill was the safety net at the outer limit. What you're arguing there, Johnny, is that what we maybe require to do is to make sure that existing regulation, legislation, is actually well known by the folks who you represent and others represent here, in order that we do get that preventative measures in play. Would that be right?
I would agree.
Elspeth?
I would agree, yeah.
You're nodding. Simon?
Very much so. We're obviously very different. You know, a single organisation rather than many smaller organisations. So for us, we take compliance with our licences, regulations incredibly important for us. So we for us as an organisation, we're very focused on making sure we are compliant. Occasionally we aren't, but the vast majority of time we are.
Catherine, would that go for your members?
Yeah, broadly speaking.
Okay. Thank you very much. Thank you, convener.
Okay, Kevin, I wouldn't thank you. We're back to you, Mark, now. If you have any questions.
Yeah, so I'm interested in a scenario where the bill, as it stands at the moment, is passed. And I'm interested in what you think will then change in your sector as a result of that. So whether it's about governance, whether it's about risk management. So, Catherine, you represent a wide range of interests. I mean, I would imagine you've got, you know, big oil and gas majors in there, Shell, BP, very complex forms of corporate governance, right the way through to SMEs. But let's start with the bigger companies. What are your bigger members telling you would be the impact in terms of the culture within the board, around governance, around risk management as a result of this bill going into law?
So from a larger member point of view, it possibly is slightly easier because they will have the expertise within the organisation to look at examples that, you know, elsewhere we know in kind of Europe or the kind of Pacific Islands, kind of, you know, broadly speaking across the world, there are examples of where legislation like this is already in practice. I think there would be learning that could be taken from there. From a smaller organisation point of view, that's where our concerns sit, because again, you've got smaller boards, you've got different types of kind of expertise around the table. It's how do we make sure that people are equipped with the resources and the knowledge to be having the right conversations in the boardroom to make sure that they don't unintentionally get caught out. And again, for me, that comes down to kind of the proportionality element of this around kind of penalties and punishments. I know it's come up a few times, and I know the point has been made about kind of the criminality side of things, but there really needs to be time put into the guidance notes around this to help people to be preventative rather than reactive.
Okay, so that kind of surprises me, really, that some of your larger corporate members would not have a concern about this, but it's more the smaller members who think that they may be in a position where an ecocide event might be possible under their control. Is that right?
It's not that they wouldn't have a concern. I just feel from kind of the conversations we've had, they would be better equipped to act.
Better equipped, right? Okay, to deal with it. Okay. So, Simon, from the perspective of a state utility, then, what's the change?
So, as with any new kind of legislation or regulation, we would obviously consider what. We would obviously need to look at it and understand from a board and a leadership perspective whether or not our current processes and our current risk appetite, for example, would need to adapt to meet that new regulation. And a big part of that will be making sure the senior leadership, for example, across the business understood the new legislation and also what constitutes good or bad practice against it. So I think, first of all, we're quite used to new legislation and new regulation coming in. It's about making sure that we understand it, make sure that the board, for example, as Catherine mentioned, would understand the implications of it and to be able to test us whether or not we are, whether or not we need to any change to our processes to meet it.
Okay,
I would hope not.
But there's no immediate changes. I mean, you operate in a highly regulated environment, ministerial objectives, economic regulator, that system is fit for purpose.
Yeah.
Under this bill.
Yeah.
Okay. Elspeth, you said something earlier on, I think I picked you up right, where you said that there are some concerns within the sector about the lack of investment in enforcement. Is that a concern with this, that basically there could be situations where fishers, say, for example, go into an area where there's a species, it gets fished out, that could constitute ecocide, but because there's a lack of enforcement, is your point that licensing and enforcement of the license should have kicked in earlier, and therefore people are in a difficult circumstance? I'm just trying to imagine it from the fisher's point of view. What's your concern here? What changes as a result of that? Are you very much reliant on the state effectively requiring you to stick with the licenses and enforcing that? does this bring in something new, which is a new set of responsibilities for you? And how do fishers collectively address that challenge?
No, I think my issues are different. I think what my sector is concerned about generally is a diminution of resources in Marine Directorate and what that is able to deliver across the piece. And I think it is, I think before parliamentarians embark on such a significant measure as is set out in this bill, I think it is important to have an understanding of the effectiveness of existing legislation and its enforcement thereof. Your question around what would change in the sector if the bill was passed as it stands, I think because it is not clear to me about what is and what isn't ecocide, it is not clear to me whether cumulative impact by lots of different actors could be considered as ecocide, then, like Johnny, the vast majority of the members of our industry do their best to be compliant. If they are not compliant, if they are deliberately not compliant, then there is a book there. That book should be thrown at them. But what would change in the sector? I think the vast majority of people would still continue going out and doing what they do because that is a legitimate, regulated activity. I think what would change is not so much in the sector, but I think we would start to then see very considerable pressure coming from some of the environmental NGOs to put pressure on regulators to say, my goodness, you know, this is cumulative impact of trawling, for example. This is having widespread impact. This will be long-term. This could be, you know, this could cause environmental harm. So my concern would be that our legitimate regulated activity would be seen by others as passing the bar for ecocide as the bill is currently drafted, and that would be my concern.
So is your concern with the Marine Directorate that there isn't the agreed science? So it could be that fishers are going to an area, you know, trawling, dredging, but there isn't the understanding about the impact that has on species, and therefore someone could come back later on and say, well, hang a minute, you've just dredged out the last remaining, I don't know, flame shell reef or something else. Is it the shifting nature of data and understanding the environment which is causing your members the concern here, because you don't know if you're going to retrospectively be challenged under ecocide?
Well, it's a little like the point that I think Johnny made earlier about something down the road being seen as harmful that at the time was perhaps not well known. I mean, I think, let's be honest, nobody has a completely comprehensive understanding of what the seabed looks like. You know, it's a big area. We have the understanding that we have. We have a very extensive network of marine protected areas. I will be coming in front of another committee next week to talk about fisheries management measures, restrictions on bottom trawling in a number of these marine protected areas of which we are supportive. So I think we have to recognise that we've already got, we've got limit, you know, we don't know everything about our environment. We don't know everything now. We can't predict what's going to happen in the future. So I think that's why, again, we have to be very careful with a bill of this sort, that it recognises that, you know, we live in a kind of imperfect world in terms of knowledge, and what we don't want to see here are unintended consequences that were not foreseen today that are going to criminalise people for perfectly legitimate activities.
Okay. Johnny, what changes?
I haven't much more to add, but I'll probably take us back to some of the initial conversation around that lack of clarity on things like widespread, for example, because the bill itself talks about geographic area and so on, or particular impact on a species, and a species could range over a huge area, or an ecosystem, which could, again, all of those things can traverse, if that's the right word, a whole multiple range of different agricultural businesses. And it would be very difficult, from what I see from the bill, to point a particular finger at all of the businesses that are operating on that widespread sort of scale, if it's a landscape scale or a catchment scale, when it's looking at a particular criminal activity, if that's what it is. So I go back to the point that we've made a few times today already, that actually the existing regulations, if there are individual farmers or crofters as businesses who have breached an existing regulation, then they will be subject to the existing sanctions. So I'm struggling to see, particularly on that widespread, long-lasting element, how that would work in an agricultural context, because there are very few agricultural businesses that operate over a whole catchment or a whole geographical area or impact on a whole species or a whole ecosystem. They might be responsible for their bit and what happens on their bit, but that's already covered by existing regulation.
Okay. Just moving on, do you have any comments on the defence of necessity that is in the bill? Are there any examples where that would come up as a defence from any of your sectors?
I can't think of anything specific as an example from a farming or crofting point of view.
Yeah. Anyone else?
Well, I think there's a defence of necessity in terms of producing food. It's a necessary thing for humanity to have. So that would, I mean, I think I put in my in the call for evidence. I touched on a couple of non-food production examples. I touched on the Scottish Government's flagship policy to expand the development of offshore wind, which we know will have significant environmental impacts that will be widespread and long term. But I'm sure that they would claim a defence of necessity, saying, but we must reduce our fossil fuel emissions and therefore that is the greater good. Road building, airport expansion. You know, is there we heard yesterday of Gatwick Airport having approved a second runway. Now, that's not within the jurisdiction of this administration, but, you know, is it a valid defence of necessity that people want to go on more holidays, perhaps? So I think there are examples of defence of necessity, and from my perspective, a defence of necessity is the necessity of producing food.
Right. Well, that's quite broad, though, isn't it? Because you could put a wind farm in one location and perhaps have less environmental impact. You could fish from a part of the sea where there isn't environmental pressure, but I see the point you're making. Again,
I think that comes to the point of it. I think there is much more needs to be. I think the defence of necessity and how the sort of balancing of these things would be judged is not clear. I think there's a lot more that needs to be made clear around that.
Okay, Simon, are there particular examples in the water industry where something could be absolutely necessary?
Well, abstraction for drinking water would be the obvious ones. We abstract from many sources across Scotland. Some of those are in particular this year, are in in essence, kind of struggling in terms of availability of water. You could foresee that there will be a case where we would need to abstract for, in essence, kind of provide drinking water to households that could have a negative environmental impact. We work very well with SEPA at the moment, managing that in terms of doing that. But I know some of Johnny's members, for example, may have restrictions on them because of abstractions, because we need to make sure we're abstracting for supplying potable water to the communities across Scotland.
Catherine, anything to add on that?
No, nothing to add.
No, okay. Back to you, convener.
Okay, thank you. The next questions come from Michael Matheson. Michael.
Thanks. I want to turn to sections 1, 3 and 4, which deal with the issue of liability within the bill, split broadly into two forms, one on an individual basis, which is the intent or recklessness, and on the responsibility of an organisation or individual within an organisation, the consent and connivance provisions within it. Some have suggested that the threshold that's been set for liability in the bill is too high. Do you agree? Elspeth?
I don't have a particularly strong view on this. I think it's something that I would like to explore further. Okay. I might be able to come back with some written comments on this, but it wasn't a part of the bill that we spent a lot of time agonising over.
Okay. Catherine?
Likewise, nothing specific, but I think we do have some questions around what would kind of constitute reasonable precaution, due diligence, and from a kind of point of view of how our members or directors could demonstrate that. I think, again, it comes down to kind of questions around definitions.
Okay, Simon?
Yeah, nothing further to add, Deputy Convener. I think it's one, as the bill develops, we'd need to understand the specifics.
Okay. Johnny, do you have a view?
No, other than to echo what my fellow panellists have just said.
Okay. The bill also makes provision around vicarious liability. And I'm going to come to you, Johnny, because there was some evidence that we heard earlier on this morning from Panel 1, which suggested some of the changes that came about through vicarious liability provided for within a piece of wildlife legislation resulted in a culture change going through the sector. Is that your experience?
Certainly when that legislation went through, it raised a lot of concerns around the relationship between employee and employer in terms of whose responsibilities it was. But I don't think it's a particularly live issue now, because I'm not aware of any particular cases where vicarious liability is an issue. But clearly there is now a precedent within other pieces of Scots law where vicarious liability is part of that legislation. And again, a bit like echoing the previous question, it would be something that we would need to think about quite carefully, because clearly the business is one thing, but the employees and the actions of individuals can be another. But the vicarious liability issue clearly links those two things together. And I think that's it's probably more for a panel of legal experts than certainly myself. I can't speak for others.
Okay.
But it was a concern before, as you quite rightly identified, and I suspect it might be a concern now, but I'm not sure how it would play out in reality.
Okay. Is anybody else in any other sectors had an experience of changes coming about as a result of its introduction? No. None? Okay. And my final point is around the issue of who should be liable. So we heard some evidence in the earlier section that saying that liability should rest largely and solely, I think, be fair to say, I'm sort of paraphrasing here, I think, but should be with the decision makers, the directors within the organisation, and that the workers should be protected from the provisions in the bill. Can I ask you, Catherine, given your members are directors, what's your take on that suggested change to the bill?
Again, it's a kind of very much caveated one that, yes, I see the principle of that, but again, our members would be looking for reassurances that they wouldn't be scapegoated, and be to blame for employees that take matters into their own hands. It would come down to interpretation, guidance, definitions, and how that's positioned. But we can accept that it would be the decision maker of the organisation that it would sit.
Okay, and Simon, you're a director within a public agency. Do you think you should be liable for the actions of your organisation, irrespective as to who carries them out, which could carry a criminal penalty up to 20 years in prison, potentially?
So I think when you take on the role of director, you accept that's part of your responsibilities as part of that. And probably the easiest way to think that is around health and safety legislation. We all take on responsibilities associated with health and safety legislation, and we're very, very aware of those as part of it. And I think, as Catherine mentioned, the key one is what's linked to corporate action or corporate negligence, and what's linked to an individual's actions, and how do we separate those two out? And I think that would need developing as the bill progresses.
Okay, so just so I understand this properly, so because I was from the last session, so if someone in your organisation carries out an act that then results in, under this bill, is defined as ecocide, who do you think should be liable for being prosecuted for committing the offence? The person who initiated it or the directors?
So I think it would need to be, well, I think a lot of this can be quite hypothetical at the moment. So if it's something that is, the individual is following guidance or process or a determination or, in terms of from senior management, for example, if I understand our current environmental regulations well enough, us as an organisation are, in essence, prosecuted, not the individual as part of that. I think I'd need to really understand the difference between the individual act versus the corporate act on this one, and I'm not. I'd need to link it through to what the health and safety legislation actually gave us, because that's where I think the only example I could think which would be equivalent.
Okay. Any other comments on that? No. Okay. Thanks, Convener.
Okay, I think that's an interesting situation, because I don't think doing something which you know is wrong is a defence from doing that act. I think history's proven that saying you were following orders isn't a good enough excuse for doing something wrong. So I wasn't quite sure I followed in the previous thing. The Deputy Convener's mentioned, unlimited fine and 20 years in Nick. Unlimited fine might mean nothing if you've got a huge bonus. A fine of 500 quid for somebody who has very little income, maybe in the form of a crofter, might be a massive and might be a death knell to their business. So I don't quite understand how that range works. But my question was one of the suggestions was linking fines to the turnover of the organisation. So how would you feel about that? Scottish Water, massive turnover, massive amount of money, compare massive fine. Crofter on the West Coast, very little turnover, should only have a very little fine. What do you think? Simon, do you want to refute that comment?
Well, I think... So it's probably not for me to decide whether or not what level the fines are. I think taking money out of a public sector organisation, it would need considering whether or not that's the right outcome for us as an organisation.
Well, that's an interesting idea, because it's public sector, it doesn't get a fine. I'm not sure that's quite what you were saying. That's my interpretation. Johnny, what are your views on it?
Well, the word would be proportionality, wouldn't it? But in two senses, proportionality in terms of and it goes back to this issue about the extent and the long-lasting nature of the environmental damage. I think to set a fine, but then also I would agree that proportionality in terms of the impact it would have on the viability of the business, because I'm pretty sure that this bill, its intention isn't to put any business out of business, but is intended to proportionately punish, if required, in the proportionate way, if there's a criminal act being committed. So it's proportionality in both ways.
Okay, I'm going to come to the next questions from Douglas and then a couple from Monica.
Yeah, thank you, Convener. And I was just going to go back. Elspeth, you mentioned unintended consequences of this bill earlier. So do you fear that environmental NGOs will rush to the police and use this bill and try and outlaw some forms of legitimately legal and justifiable fishing or farming going forward?
Yes, I do have concerns in that regard. I think it is well known that there are individuals and bodies who don't like what the fishing industry does. Yep. They don't approve of practices that are regulated and legal. And are an efficient and effective way of producing affordable, healthy food. But we know there are many who oppose that, and I feel that as this bill is drafted, it creates the potential for those claims such as those to be made. That is something, and I think I made that point in my response to Mr. Ruskell.
And Johnny, is that something, a fear that you share as well?
Yeah, absolutely. At the end of the day, along with Elspeth's sector, the food and farming sector of Scotland is not only vital to putting food on people's tables, but is actually the most important sector of our economy and is a catalyst for economic growth. So the last thing we want to do is to overly burden our primary producers to the point where they are, what's the right word? I'm trying to think, almost at fear of actually going about the practices that they do in order to deliver the outcomes that we all need and require.
Mm-hmm. Okay, thank you. And moving on to enforcement now, so I've touched on it already, but do you have any views or concerns about how the bill might be enforced, or the resources required to effectively enforce the bill? Maybe Simon, have you got a view on that first of all?
I think note to that, Ms Lumsden. I think that would be a question really to ask to SEPA if I were the agency, for example, in terms of implementing the bill.
Well, I guess, is it clear who's going to enforce it in different areas?
Yeah, not to me at the moment, no.
Okay. Elspeth, do you have a view on that? Or?
Well, it's not the enforcement provisions aren't clear to me, no. Possibly because we have very different regulators in fishing. SEPA's jurisdiction doesn't extend beyond 3 nautical miles, I don't believe. So I think the enforcement provisions for anything in the marine sector would need to be considered further. Okay. But I think there is this broader issue around resources that I think all regulators face. And I think it is important to have a greater understanding of whether, I think somebody earlier touched upon, there haven't been many prosecutions under the Regulatory Reform Act. But is that because they have not been successful? Is it because the bar is too high or not high enough? Or is it because regulators are not sufficiently well resourced or supported to enforce more? So I think there's a number of issues there that need to be further explored.
And Johnny, in terms of farming, is it clear who would be enforcing this?
No, I suspect an awful lot of it would fall into SEPA's remit, but there would be other aspects in terms of the Rural Payments Inspection Division of Scottish Government and also NatureScot. We haven't really mentioned NatureScot in terms of habitats and wildlife. So, and I know that all of those agencies, if I can call them that, are very much under pressure. Again, whilst we require, and this is a bit of a general statement, whilst we require a backstop of regulatory baseline, if you like, in order to prevent environmental damage of any form, where we really need to be, and where I think certainly the agricultural industry wants to get to, and I suspect fisheries is exactly the same, is that actually we want to do it in a much more sustainable way going forward, because that's what we're being asked to do. And in doing so, we're delivering on our ambitions around climate and biodiversity and other things as well. So purely doing things on an enforcement basis and a regulatory basis alone isn't going to get us there. It's about seeking out good practice and best practice that's going to be important. And I actually see that as a role for the agencies of government as well. It's not just about enforcing the law.
Okay, thank you, Convener.
Sarah, very, very briefly.
Just a reflection on that last comment. If organisations, whether businesses, farmers or whatever, are actually complying with legislation, whether it's planning or a permit, why would they be liable rather than the government or regulator, if actually that is the responsibility in terms of ecocide?
If the obligation was on the regulator rather than the individual.
Well, if somebody is actually committing ecocide allegation, if they are in compliance with the government's regulations, then would it be lifted up to the government to be responsible? Just a question, maybe, if leave it on the table.
Yeah, that's not for me to comment on this.
Well, just thinking about accountability in terms of raising the bar and expectations.
It might be then who is in the government that you told accountable. Mark, if it's really, really quick, you had us up really quick.
I'll move. I know Monica wants to come in, so I'll leave it.
Okay, thank you. Monica.
Thank you, Convener. I'll try and squeeze quite a lot in. I'm conscious of time and we've had some really good sessions today. Johnny Hall, I'm going to come to you first of all, because I read with interest in a few Scotland's written submission to the committee. And I just want to be clear in my mind, because some of what you've said today does differ from some of the written comments that you made. So in your written submission, you say that NFU Scotland is broadly supportive of the overall aim of the bill to criminalise the most serious forms of environmental harm. You say that you understand that the bill intends to fill a gap between existing environmental regulations and criminal law, similar to other ecocide legislation found across other countries, and acts as a deterrent for the most egregious and reckless actions that could cause irreversible damage to ecosystems. And you also say it's unlikely to affect the day-to-day operations of most agricultural businesses. You're satisfied with a number of safeguards in the bill while calling for clearer guidance. So I just want to check, because the committee will look at written evidence and oral evidence. Is there anything in your written evidence that you want to change or clarify?
Not at this moment, no. I think the questions we've responded to, I've responded to this morning, were very clear in the sense that, is it necessary? No, but if it comes forward, it would provide those extra backstops. And I think that was a point that Mark Ruskell was making. If it came into force as an act, would it provide that additional safety net, call it what you want? But as things stand, and as the thing we've been on record as saying from day one, is that there is an existing raft of environmental regulations which ensures that farming and crofting is highly unlikely to cause what might be an ecocide event in this context. So because of the very nature of the agricultural businesses and the fragmentation of those that we're talking about, and the fact that there is all that regulatory protection in place.
Thank you. And you've rightly highlighted today the importance of food production and food security. The Nature Friendly Farming Network, who represent some farmers, support ecocide law because they want greater protection for soils and wildlife, forests and biodiversity. Do you recognise that ecocide law is coming into force in other countries because of the benefits it can have to farmers and food producers who also can be the victims of ecocide level crime?
Yes, I can understand that there is the potential that individual farm businesses might be the victims if there was a significant land-related or water-related pollution event. But I think, as we just touched on in the earlier bit, about the fact that for individual farm businesses, not only protecting our soils and our water quality is a requirement, but it's actually in the long-term interests of farming and crofting and food production in Scotland. We absolutely need to get on the front foot around that sustainability and regenerative intent that we do have, and we're working with Scottish Government on sooner rather than later. Soil health and the management of our ecosystems and ecosystem services are so fundamental to food production activities. Pollinators, all the rest of it come into play. So farming is all about working with nature, not against it.
Thank you. Briefly for Elspeth MacDonald, when I know the Scottish Fishermen's Federation are blanket opposed to the bill, and that's been your position from the very beginning throughout the early consultation development of the proposal. So I'm guessing that there would never be an ecocide bill that you would come to Parliament and support. But we heard from an earlier witness this morning that major oil disasters like Brer, although we're not saying that Brer was an example of an ecocide crime, because that law did not exist. But could you say something about the impact or potential impact on your members when we have such events and that could happen in the future in terms of widespread impact and pollution and disruption? What could that do to a business like those that your members conduct?
Yeah, I mean, firstly, I think I wouldn't go so far as to say that SFF would never support an ecocide bill. I think an ecocide bill with the correct safeguards and addressing some of the points, well, all of the points in our written submission and some of the points we've made today. So I think I would never say never, because we have concerns about this bill as it is drafted, but that's not to say that we would necessarily have the same concerns in another form that addresses the points that we make about safeguards. I think the point you make about things like oil spills are valid. It's interesting. I had just written that same word, these two same words down, and I think again, well, if you look at something like that particular incident to which you referred, there was an impact. It was a long time ago. It was long before I was involved in this industry. But actually, what that impact actually was on fishermen at the time, I am not sure actually whether that was long-term and widespread and had significant ongoing impacts. But I think, we have to recognise that sectors and businesses can be affected by the actions or inactions of others. But I think it's really important to be able to distinguish between things such as, for example, when these are the consequence of an accident, as opposed to something that happens willfully or intentionally. So I think there's just a lot to explore in there in terms of how all of this would weave together. But your point is valid around certainly our businesses could be affected by others. I think if these were, but yeah, there's just too much, I think, to unpick there.
Yeah, no, thank you for your evidence, and I'm open to listening. And just finally, I mean, this was primarily for Professor Parsons, but Catherine is welcome to contribute too. I think I've got this correct, that Simon, you're a director in Scottish Water. Yeah, that's correct. So you could potentially be culpable under the terms of the bill as drafted if there was an ecocide crime. We do know that water companies have illegally discharged raw or untreated sewage into rivers and seas. I won't name any particular examples, and that's caused significant damage, resulting in very significant fines. What would an ecocide law, what would that mean in practice for directors like yourself and discussions in boardrooms like in Scottish Water? What practical difference would it make to how you approach governance and prevention and culture and behaviours throughout the organisation, and how much internal discussion has happened in Scottish Water about your position on ecocide law? Has that gone beyond director level?
I am going to squeeze your time on this. Please make it as succinct as possible. It was quite a long question.
I will do. I mean, first of all, on the discharges to the environment, I think I just need to address that. So we have licensed discharges to the environment. Sewer overflows are a core part of our infrastructure, so they're a big part of how we operate. As in existing legislation for environmental pollution incidents that allows SEPA to prosecute us, fine us, for example, on that side. So to me, there's a very robust set of rules and regulations, legislation around that activity as part of that. In terms of what impact would this have on us as an organisation, I think I answered the question earlier. So we would obviously, once we understood the more detail around the regulation, the guidance that would come with it, we would see how does our current processes mean that we would operate with inside it, and we'd make sure that, for example, our senior leaders, our board, our directors, non-executive directors, for example, would understand the regulations and the legislation that came with it. So as we would do with other significant pieces of new regulation.
And Catherine, if you're going to answer that, you may only say how you would differ in your approach to what's been suggested there. I'm just sorry, we are up against it.
All I would add is there would be a role for an organisation like the IOD to upskill our members around what the implications of any kind of bill would be.
Great. Thank you.
Okay, thank you. I think this morning's two panels have raised a whole heap of questions that the committee will want to consider in relation to this bill, and some hypothetical situations which we may want to discuss so we understand what's happening. But I think it's been really helpful. Thank you very much. I am going to ask you to leave the room as quickly as possible because we are up against the clock and we're about to go into private session, so I close this part of the meeting.